Good morning, everyone. I'm Carrie Holmes. I'm the Pro Bono Director at the Harriet Buhey Center for Family Law. And along with my co-chair, Ron Reichstein from Youngman Reichstein, we welcome you to the Family Law Symposium, Litigating Financial Issues During COVID-19 and Beyond. We're really grateful that you're all joining us here this morning. We are going to start the day with some opening remarks from Judge Riff. Then we'll have the first panel about COVID considerations for support issues. Then the second panel about asset valuations during hard times. And then we will be switching to a different Zoom link, which we will send in the chat and in an email, and we'll give you instructions, don't worry. For some breakout rooms. We're calling it a chat break in the 12 o'clock hour or so to hopefully recreate a little bit of getting to meet with our colleagues and network with them in person like we used to at the symposium. Then after that, we will have a mock trial presentation about taking testimony using LACourtConnect video. Again, thank you so much to all of our panelists, and thank you for the attendees for being here with us.
Yes, thank you everyone. And I wanted to just thank our sponsors. First of all, we wouldn't be able to do this without them. So we just want to run through some names, so bear with me. The Family Law section and all of its programs is sponsored by SoberLink, White Zuckerman, Warsavsky, Luna, and Hunt, Our Family Wizard, and event sponsors for the Family Law Symposium are Signature Resolution, Gursey Schneider LLP, Ron J. Infuso CPA, Feinberg, Mindel, Brandt, and Klein, LLP, Californian Estates, and ARC, Alternative Resolution Centers. Our gold sponsors are Jaffe Family Law Group and JAMS. And now we have some opening remarks from our esteemed supervising judge of the Los Angeles Superior Court, Lawrence P. Riff. Your Honor, take it away.
Good morning.
Morning.
Thank you, Carrie. Thank you, Ron, for all you do. Thanks to the Beverly Hills Bar Association for all you do. Sponsors, thank you very much for sponsoring. So today I want to share with you some of the things that happen far from the public view in the Family Law Division. First, I want to share with you some of the things we say about you behind closed doors. And second, I want to share with you a process we're engaged in right now, the annual Judicial Officer Assignment Preference Survey. And then I want to talk about how these two things interrelate. So let me open the door a little bit and tell you what we say about you behind closed doors, we being the judicial officers in the division. I'm not blowing smoke at you when I tell you that behind closed doors we say that we really respect the work that you do and that we admire the spirit of the family law community and especially the pro bono work that you all do in furtherance of families in our community. And at a personal level, most of us say that we like you very much as individuals. Speaking for myself, I really enjoy seeing you in court, seeing you in the hallways, getting to know you better. One of the things I hear my colleagues say constantly is, you know, being a judge in family law is really tough, but I can't imagine how hard it must be to be a family law practitioner. What else do we say? Well, we say we think there are too many ex parte applications for situations that don't colorably rise to the level of exigency, irreparable harm, or immediate risk of harm to a child. And frankly, we're baffled often by why an ex parte application is brought that seems DOA. It's a hope of ours that you will continue to counsel your clients who think their situation warrants jumping ahead of the line, not to make the attempt. It's expensive for them. It's expensive for the other side. It opens them to sanctions. It's a huge distraction for those of us on the bench who have to stop what we're doing to read those papers. And for the most part, it's just not going to work. And please counsel your clients that by and large, the alternative request for an order shortening time probably is not going to work either. What else do we talk about? We talk about our old friend meet and confer. And we say, we're so appreciative of counsel who take that responsibility, that professional responsibility and that legal responsibility seriously. And when counsel have genuinely met and conferred and genuinely narrowed the dispute, we're grateful and we see it as a sign of very good lawyering. And we're chagrined, and we comment frequently among ourselves by how often counsel don't meet and confer, or their view of a meet and confer is to exchange a few nasty emails and then drop a hot potato in our lap. What else do we say behind closed doors? We say, dude, get to the point. Beethoven's Ninth Symphony reaches its apogee in the fourth movement. In order to get there, we have to sit through the first three movements, and that's a pretty pleasant experience, but not so in family court. If your point is to come into court and to start singing Ode to Joy, Beethoven's fourth movement, then your argument should be, Your Honor, we're here to sing Ode to Joy and then start singing. We don't need the first three movements. And seriously, you can never go wrong, we say to ourselves behind closed doors. You all can never go wrong by starting every brief and every oral argument with these two sentences. First, Your Honor, the narrow question before the court today is, fill in the blank. Second sentence, the correct outcome on that question today is blank because blank. Never go wrong with that. The other thing we say behind closed doors is slightly more abstract, but here it is. We recognize that your business model is in serious tension with our aspirations as to how we think the division should operate. Our aspiration is for a smooth, swift, predictable path to entry of judgment with few post-judgment proceedings. And that's not consistent, we recognize, with a business model where attorneys work on an hourly basis off of retainers. Now, we're not criticizing your business model. We know it is the economics of the world in which you must operate. It's not a criticism, it's an observation. And I'm going to return to that in just a few minutes. So what else is happening out of the public view? This is the second thing I wanted to mention. We, and by that I mean the nearly 600 judicial officers of our court, are at this very moment engaged in an annual exercise where we formally advise the presiding judge and the presiding judge-elect in writing of our assignment preferences for the coming year. We identify in what division we wish to serve whether family, criminal, civil, or other, and the geographic location in which we wish to serve. The very first question on that questionnaire is, do you wish to stay in your current assignment? Yes or no? So it's a moment of truth for the supervising judge of the Family Law Division, because I get to see who among our ranks wants to stay and who wants to go. And for me, who has made retention of talent in the division the preeminent goal, it's a referendum on how I and we are doing in keeping folks in the division. I don't think I need to tell you why keeping judicial officers in the division is in the public interest. It's enough to sum it up with a few code words. Here they are: brain drain and revolving door. I'm happy to report that the vast majority of family law judicial officers answered question number 1, yes. They wish to stay in their current assignment. And frankly, it doesn't surprise me. The work itself is intellectually stimulating. It's emotionally satisfying. And for those of us who wanted to become judicial officers because at the end of the day, we wanted to help people, which is really the common denominator, family law is a very straightforward way to help people every day, and we feel it. But several of our beloved and very valued family law officers, judicial officers, do wish to move on to a different assignment. And I think it's important to have the courage to ask the question why, and to have the courage to try to ameliorate the situation. Now, some judicial officers want to move on simply because they want to experience the spice of life and try something new. I don't blame them. In fact, I'm one of them. It was a whim because I wanted to taste the spice of life that I asked for a family law assignment. I had no idea what I was doing. I just wanted something new. But for others, the reason they want out is because of one easily understood reason. Here it is. In cold technocratic language, demand far exceeds supply. Demand far exceeds supply. But to put it that way is to not get to the heart of the problem. What's the problem? We know that there are families in pain and children in distress, and they need court orders. Not in 4 weeks, not in 6 weeks, but now. But there are only so many hours of the day, only so many foreign language interpreters in court, only so many family court services professionals available, and people have to wait. We judicial officers are constantly feeling the anxiety and stress of having to wait. And you want to know what that feels like? I'll tell you. You know how you feel when you're late for a meeting and stuck in traffic, and your stomach is tight and your heart is beating? That is how we feel much of the time, day in and day out. And the work we do day in and day out is very demanding, intellectually and emotionally. And we're doing it through masks, and we're doing it on computer screens, which makes it that much tougher. When you're a judicial officer in family law, you can't have an off day. Every day is game day, and you need to be on your game. So that's a high bar to meet. After 2 or 3 years of all of this, day in and day out, the emotional strain, the anxiety and the stress, the trauma, some judicial officers say, you know, I need to do something else. This is not a new problem. I have not been in the family law world that long, but I've been around long enough to know This is not a new problem. It goes back decades. So we have some fundamental problems in the division, the common denominator of which is that demand far exceeds capacity. My answer to that, going into 2021 as your supervising judge, is it cannot be business as usual. If some of you have already heard my metaphor on this, I apologize, but I like it so much, I'm going to do it again. So in September, when the state of Oregon was on fire and the state of California was on fire, I heard a guy from the Bureau of Land Management being interviewed on the radio. The fire lines were 15, 20, 30 miles long. And this person said, you know, the problem isn't that if we only had 3 more fire engines, we could solve the problem. This problem is going to require a fundamental change in forest management. And I thought to myself, you know, it's not a perfect analogy, but it's sort of how I feel about the family law division. Getting 3 or 4 more judges and 2 more commissioners, which would be great, by the way. And I know Judge Taylor coming in would love to do it if he could. It is not going to address the fundamental problem. It's 3 more fire engines. And what I say is we need to fundamentally change forest management practices, and we're not going to do it overnight. I suggest to you that there are 2 tools available to us, 2 broad tools available to us. One of them is moving cases more purposefully and smoothly through the system. In the past, I've adverted to that as muscular case management, but I think that term may be misunderstood. And the second tool I draw from the world of management, which is to reduce the number of touches on the file. Touches on the file. You already know about this from your own law practice. The most efficient way to handle a piece of paper or an email in your practice is to handle it once and be done with it. If you are touching it 2 or 3 or 4 times and 2 or 3 other people in your office are touching it, every time they touch it, there's an administrative and time cost. So too in the court system. How many times do we as judicial officers need to touch the file, and who else needs to touch it? Every time there's a continuance of anything, our judicial assistants need to create a minute order, a certificate of service, reduce the number of touches. So here are some propositions I have for you. I think I'm still doing okay on time. I contend that it is the duty of the court to drive forward progress in family law cases. It's a duty of the court. When our cases are going to be driven by the vigor or the lack of vigor of the litigants, and the litigation will from time to time episodically become red hot and then go stone cold. When that's how forward progress of cases occurs, I contend it too often leads to unacceptable delay, unacceptable expense, a misallocation of private and public resources, and an unacceptable lack of finality. It often enables unacceptable emotional and financial abuse. Thus, I say it is the first job of the family court to be judicial officer, to be purposeful, and to apply strong case management. And by this, I mean that judicial officer should consistently and constantly be identifying and implementing a case-specific plan to enhance the party's ability to solve their own problem, or if they can't, to get the case to trial. So, as I say, you've heard me in the past preach the gospel of strong, muscular case management. What does it mean practically? I've heard some of you say. Here's what it means. That every time you're in court on anything, the court is going to set a control date, a date in the future for a future appearance, and will give both sides performance tasks to accomplish. And that there should be consequences if those performance tasks are not accomplished. It means the judicial officer needs to ask a penetrating question or two at every hearing. Counsel, what additional information do you need from the other side in order to be ready to have a meaningful settlement conference or go to trial? And then right there and then, make orders if necessary. Oh, you need bank statements? Counsel, what's the problem with the bank statements? When can you get the bank statements? Any problem with my making an order that you're going to produce the bank statements from that account in the next 45 days? No, so ordered. You need the deposition? When do you want to have the deposition? Counsel, when can your client sit for a deposition? I'm going to set the deposition by court order. You're not going to have to worry about a notice. Counsel, what is petitioner's proposal for disposition of the family home? Is he going to buy it out? Are they going to sell it? What's your plan? You don't know? Why don't you know? When will you know? So it's a little uncomfortable maybe, but that's what I'm talking about. And sometimes strong case management means this. Folks, I'm setting your case, which is now 25 months old, for trial in 6 months. And I'm setting it right here and now. And you should plan on getting your work done because fact discovery cuts off 30 days before your trial date. And your trial date is firm. Not trying to be unpleasant, not trying to jam anybody, but we need to drive these cases forward. Next, how do we reduce the number of touches? Here's my view on that. We need to develop and employ a more rigorous differential case management structure for the division. And I'll keep this short because it's a complicated problem. I will tell you in the academic world of family law, when you read what people are publishing on, it is this topic. It is differential case management for large family law courts. Different kinds of cases require different pathways, and those pathways can and should be identified early and resources properly applied. I contend this will permit greater efficiency and a fewer number of touches. So the first pathway is for streamlined cases. These are cases where there's minimal judicial decision-making required. The cases are going to be resolved on paper, and the goal is to get the parties to a swift resolution with minimal court resources. There need to be safeguards in any streamlined process to make sure that there's the ability, for example, for a deviation from guideline child support, to make sure that agreements are not the product of fraud or coercion, and that sort of thing. A second pathway is what I'm calling a tailored services model. This is for most cases, frankly. These are the large class of cases that are not suitable for a streamlined pathway, but nonetheless present pretty straightforward and typical issues that are unlikely to require specialized case management or specialized expert involvement. These are the cases that I contend have a high likelihood of settlement with the involvement of a mediator or settlement officer. And I contend that currently in our culture, we wait far too long to engage that neutral in the process. I suggest that for these cases, shortly after the service of a preliminary declaration of disclosure, the parties really ought to engage for 2 or 3 hours with a neutral, whether judge or a volunteer from the community. Those 2 or 3 hours, I contend, will save thousands of dollars and multiple hours down the road. And employing such a method is also going to help the litigants to internalize the understanding that this is their case and the resolution of it lies within their ken and their prerogative. They have the responsibility for getting their case resolved. Now, I know that there's a school of thought among some that litigants need to be worn down before they can find their way to saying yes to a settlement. And I just tell you, I don't accept a wear down or capitulation model in family law. You've done this a lot longer than I have. You've represented clients, so I recognize you may know more about this than I do. But I nonetheless reject a wear down or capitulation model because the cost on the litigants, their children, the judicial officers, and the court system is simply too high. The third pathway, and the last pathway I'm going to mention, I'll call the judicial pathway. This is the pathway for those cases that really will require a significant amount of judicial officer resource. These are the cases involving domestic abuse, child abuse, substance abuse, mental health challenges. These are the cases that are likely to have counsel on both sides, likely to involve discovery issues, likely to involve more complex financial relationships. These are the cases where the judicial officer should be spending more of their time. Yet these cases that are actually few relative to the whole don't get the attention they deserve because so many of the other cases that could be more streamlined and more tailored are using up court and judicial resources. So I will tell you that I and Assistant Judge Shelley Kaufman and incoming Assistant Judge Amy Pellman, these are the things we are thinking about and working on. And I hope a year from now to be able to really demonstrate some progress. Now, in the few minutes I have left, I'm going to go from these abstract comments to some of the more discrete things going on in the division. So let me do that now. We have 2 new judges who have started, who are on the bench calling cases. They're both in MOSC. One is Judge Lee Arian. The other is Judge Jean-Marie Warren. They are both sitting in MOSC in a restraining order court. For those of you who have noticed, for those of you who have not noticed is what I should say, we now have 3 dedicated restraining order courts at MOSC. We have a couple of other more or less dedicated restraining order courts throughout the division, one in Antelope Valley and one in Inglewood. Why do we have 3 at MOSC? We have 3 at MOSC in order to take some of the pressure off of the 15 home courts at MOSC. The 15 home courts at MOSC have, as of November 2, reverted back to a 3-day on RFO calendar and a 2-day on trial calendar every week. The home courts at MOSC, the 15 home courts, are the residuary capacity for the division. We have 3 restraining order courts at MOSC to take pressure off the home courts at MOSC in order to provide some relief for the home courts in the districts. That's why we're doing it, to provide relief for the home courts in the districts. When they cannot handle a 217 hearing or a trial or a restraining order matter consistent with their calendars, they need a place to send it. They send it essentially to MOSC through Department 2. So 2 new judges, 3 new restraining order courts. We are looking at establishing some additional restraining order courts throughout the division. That turns on whether we will have the resources to do so. I think you know that as of November 2, last Monday, we modified our local rule with respect to ex parte applications in non-restraining order matters. Non-restraining order matters. We did not modify anything with respect to ex partes in restraining order matters. But in non-restraining order matters, please take a look at our new Rule 5.3A2, the bottom line of which is as follows. Ex parte applications and oppositions are now due at 10 o'clock everywhere. Prior to November 2, there was a wide variety of deadlines throughout the districts for ex parte papers. They're now due at 10 o'clock everywhere. You may file, you may present, that's a better word, an ex parte application or opposition 4 different ways now. You can email it to a resource account in the clerk's office. You can fax file it. You can Dropbox it, or you can walk it in. If you're going to walk it in to the clerk's office, you need an advance appointment. We don't want you to walk it in. We discourage that. Now, several of you have written to me and said, how am I supposed to write an opposition to an ex parte application when my opposition is due the same time the ex parte application is due? How am I supposed to do that? Now, that is a completely legitimate question. My answer to that, which I really don't have time to develop, is as follows. Number one, that was true. That conundrum has been true for years. And we know that people are filing oppositions, quote, blind, end quote, based on ex parte notice. And I will tell you that I canvassed about 20 practitioners in our community when we were thinking about modifying this rule, from big firms to public interest to small firms, to find out, do you want us now to change it? And the answer, and by the way, the change that made the most sense to us in the absence of e-filing was, well, the application would be due at 8:30 and the opposition would be due at 2:30 the same day. And virtually everybody told us, oh, please don't make that change. We cannot stop what we are doing, our court appearances that are long planned, to drop everything we're doing to work on an opposition that we get at 8:30 in the morning. So we know you're filing blind oppositions to ex parte applications based on notice. But we also know that this new local rule doesn't change that phenomenon. The other thing the local rule makes clear is if there is going to be a hearing on an ex parte application, reasonable notice is going to be given to both sides with enough advance notice that folks can register for LACourtConnect, which means 2 hours in advance of the court event. Bottom line, we don't want you to come to court to hang around to see if there's going to be a hearing, or to come to court because you're scared to death there will be a hearing and you won't be there. That's not going to happen. If there's going to be a hearing, you're going to get reasonable notice. 2 more things, Carrie and Ron. I think I'm now over time, but briefly. 2 more quick things. Settlement conferences. We have tried to make it easier and simpler with respect to settlement conferences in the division. We now have 2 flavors of settlement conferences, chocolate and vanilla. They are a mandatory settlement conference and an informal settlement conference. That's all there is. The so-called voluntary settlement conference, which required a stipulation and an order and a trip through Department 2, we are no longer doing that. So if you want to have some form of settlement conference with some judicial officer, ask for it in your home court. And your home court JO is fully authorized to set an informal settlement conference whenever it would help the case. Last, LACourtConnect, a subject about which I hear questions all the time. LACourtConnect is not ready for unbridled use of video conferencing, in my opinion. It is not yet ready. It's not yet sufficiently reliable. I'm sorry to tell you that, but it's true. Our court is working literally day and night to improve it. We have had engineers from the vendor. We've had the president and other senior officers from the vendor in LA on site working with our CTS to make improvements, but I'm not yet authorizing a wide open use of video conferencing and video hearings on LACourtConnect. So far, for the time being, we're going to keep doing what we're doing, which is you're going to get an option to register for audio, unless it's a restraining order hearing, a contempt, or a settlement conference. At that point, you're going to get, or if that's why you're having the event, if that is the event, you'll get an option to register for video. And then if you need video for a different kind of hearing or trial, you're going to need to talk to your judicial officer to get that authorization. I know that stinks, and I'm sorry, but for the time being, believe it or not, I think it is still the best way to go. Thank you so much for hearing me out. Congratulations on your seminar, folks. Ron and Carrie, I turn it back to you.
Thank you so much, Your Honor. Thank you for those insightful words from the bench. I think a lot of us will put them to good use. And now we're going to turn to our first panel, which is COVID considerations in resolving support issues. Beware using permanent solutions for temporary problems. We have J.B. Rizzo, CPA, ABV, CFF, CVA from Frankel, Reichman, and Rizzo. Sarah Luetto, Esquire from Hersh, Mannis, LLP, and Judge Reva Goetz.
Thank you, Ron. And thank you, Carrie, and thank you to the Beverly Hills Bar and to our audience. And thank you for my fellow panelists, family law attorney Sarah Luetto and Judge Reva Goetz. Our presentation is structured so that first you're going to hear from me and some economic facts based on my current research. Then you're going to hear from Sarah and Judge Goetz on how to advise your clients through this matter, through these times. And also we're going to give you some hopefully very practical tips and solutions towards the end that you can take back to your practices. Okay, so we're talking about beware of permanent solutions for temporary problems. We want to emphasize that the current situation that we're going through is temporary and it will end. We've been through a pandemic about 100 years ago, and we've been through an economic crisis about 10 years ago. So where are we at today? So I did some research, and according to data from the McKinsey & Company, which is a very large business consulting firm, and their survey has been quoted in other seminars I've been to nationally recently. Here's some economic data to consider. In Los Angeles County, our unemployment rate is currently about 15.1%. And this compares to previous peaks, so previous worst times, of 20.8% just recently in May 2020, and 13.2% in July of 2010. So we're about a similar level that we were after the 2008 recession and those after effects. And the good news is we appear to be recovering fairly quickly. At least we go from 20% to 15 in just a matter of a couple of months. Now, what happened about 10 years ago, and how did companies recover from that recession? We know that larger companies recovered in an average of 4 years. And when I say recovered, we mean to about 2019 levels, pre-COVID, pre-negative impact. Now, it took smaller companies an average of 6 years to return. So for the rest of this presentation here, we're going to focus on the smaller businesses and give you the information that we have regarding them, because our thought process is that is most of the majority of the clients that you are dealing with. So McKinsey & Company published economic data. Now I know you can't see this very well on your materials, so we're gonna skip through this page and just talk about the industries that are most impacted that we feel for most of the clients out there. And what this data is telling us, at least what the experts thought in June 15, was that small businesses in the arts, entertainment, and recreational industries, and in the accommodation, hotels and food service, will take about 4 to 5 years to recover. The spread and the difference of whether it's 4 or 5 years, McKinsey did an analysis, and one assumed that we had the virus contained and the other assumed that it was less contained. So that's for the longer periods. Other industries that your clients might be in, finance and insurance, real estate, rental and leasing, and professional information services are less times. In other words, experts predict that we will recover quicker than other industries. Okay, small businesses in general. Small businesses make up a majority of the businesses in the United States and employ nearly half of all private sector employees. So when small business recovers, that will have a big impact on the overall economy. So according to research from the Hamilton Project that was published in September, they quoted that small businesses' average daily sales is down 20% from August to January. So that's trying to capture the overall impact and across a wide variety of industries. The same survey found that depending upon your industry sector, we can all understand that, leisure and hospitality sector was most impacted. They were down almost 50% since before the pandemic. Now, this data is all negative and we get a lot of negative information. But I have found in my practice, and you may have found in yours, that not everyone is a COVID economy loser. There are some winners. There are clients out there that are actually doing much better. And so it's important not to just assume that everything is doom and gloom. For example, if you have business owners in these industries, they could be likely to be some winners. Technology and small business services, right? We all moved to home work, work from home situations. We needed, maybe we needed our IT guys. You needed some assistance there. Those guys likely very busy. Another obvious winners, probably suppliers that do all the PPP equipment, grocery stores, supplying the economy and all of us with the things that we need in this economic time. Banking and real estate, this has been very interesting because some aspects of it, like loan refinancing, interest rates are very low. People need loans to assist with their economic downturn in businesses. Refinance type guys, mortgage bankers, going really well. Leasing people, commercial leasing private property, probably not so well. Sales in real estate, I think that probably depends on your local situation. LA, we're very fortunate. We're in a very positive real estate market. I don't believe that New York City is doing as well, but other places have been surprisingly upbeat, like people moving from cities into smaller locations. Has been doing very well. Okay, now economic losers, some of the obvious ones, your favorite restaurants, your movie theaters, concerts, gyms, travel. We're all looking forward to getting back together and meeting one another face to face. And it's unfortunately, these smaller businesses are hit pretty hard. Clothing stores, small retail stores, and beauty salons, obvious. One thing I was thinking when I was researching this is, if you recall, early on in the closures, grocery stores and large retailers, your Targets, your Walmarts, they were allowed to reopen much quicker than perhaps your local clothing store and boutique shop. So even within the same industry, you have winners and losers. Auto repairing, gas stations were all not working so much, commuting so much to an office, and those industries down. And colleges and private education, they don't adapt to an online model. That's mixed results there. Okay, again, going with this topic and with this idea to not presume either your client or the other side is a winner or a loser. Within different industries, there are changes. In healthcare, for example, I had a couple of anesthesiologist type clients. Well, they're involved when you put people on ventilators. They were very busy, unfortunately, through this time, but that's a type of doctor that's doing economically well. But yet dentists and maybe some other types of doctors, maybe dermatologists, forced to close down for months, and maybe some of us are not yet comfortable going back to them, different outcome. Manufacturing completely depends upon what topics. Law firms. I know from discussing with some of you, and in the beginning part of the pandemic, maybe things slowed, but now it seems to be roaring back for many people. Law firms that are affected by jury trials still, it depends upon which side of particular cases you are on. Again, mixed results. I know about my industry, the CPA firms and business managements and accountants out there. The reporting that I hear from my colleagues in various seminars is traditional tax firms got very busy with PPP money and that type of work. They've remained sort of steady after initial shock to the system. Business management firms, however, dealing with the entertainment industry, suffering, because as the whole industry suffers, those firms suffering. And forensic accountants, well, when the courts reopened, we've, at least from talking to my colleagues, grateful to be busy. Real estate, investment banking, and real estate developers, these guys are very localized, but anytime you have economic turmoil, usually there are deals being done. And so investment bankers might not be as impacted as you might initially think. Okay, at this point in time, I'm going to turn the presentation over to Sarah, because she's now has, in this environment that we've discussed, clients coming to her and saying, hey, what do I do?
So can you go to the next slide, JB, when you have a chance? Thanks. One of the big problems, I think, early in the pandemic is a lot of clients were feeling, anxious and nervous about their businesses. They were worried about whether or not they were going to be able to pay their rent every month. They were trying to get PPP money, and they just really didn't know what was going on. So I think there was a rush for a lot of people to file support modifications, because I think they felt like their income was going to just decrease astronomically in the next, coming months. And I found that a lot of clients didn't actually have the economic data to support their requests for modifications. So I think in counseling clients, you need to see if an economic impact has actually happened to them. And, have they recorded a few months of transactions going down? Does it look like it's a continuous trend or just a temporary trend due to early closures of COVID? And do you have, the accounting records to back up your request? I think it's really important to make sure that if you are filing a modification request right now, that you actually have evidence to support your request. And you also have to consider how long is enough time to establish an actual income decline. I would invite your attention to In re Marriage of Riddle, which is a case that said that the trial court's use of 2 months of income was specifically rejected, and the court said statutes appear to create a presumption that the last 12 months is appropriate in most cases. So in looking at COVID-19 and its impact on clients, you have to consider whether or not you're going to have a 12-month average that's down, or just maybe a 2-month decrease and then a return to current income that your order is based on. The other important factor to consider is how much resistance you anticipate from the opposing side. Do you have a party or an attorney on the other side? Do you think you can reasonably discuss mediation or other options with? Because right now, for filing an RFO, you're looking at several months delay. I think I filed an RFO in October, and it's not going to be heard until maybe February. So you have to kind of factor that in when you're counseling your client as to whether or not they want to pursue these types of options. The other thing to consider is that you may need the additional time to conduct discovery, which also results in additional expense to your client. Some financial institutions and banks are asking for 60-day extensions on every subpoena that they receive. So it may take you longer to get financial records if you're, for example, the out spouse. So that's another factor to consider in counseling your client, to maybe consider mediation or other potential options. And then another factor that I would urge you to consider in advising your client of prior to filing is whether you anticipate the need that this is to recalculate the support order after the COVID-19 pandemic is over. Is this something where they are working at a company, i.e. a talent agency or law firm that had a temporary percentage-based reduction across the board that's going to hopefully come back, probably coming into 2021? Or is this a permanent elimination of business due to COVID, i.e. the closure of a business or restaurant, or a recalibration of their income sources due to the economic circumstances?
So let's talk about what the actual legal considerations are in addressing a COVID-19 support situation. Specifically, there is no specific legislation addressing COVID-19 that will have any address either setting or modifying child or spousal support. So when we're addressing this issue, the existing statutes and case law will still apply. One thing to be considered are the emergency rules limitations on evidentiary hearings, and that may also be a factor in terms of the quote-unquote cost-benefit analysis that you'll want to consider in determining how to proceed. Sarah's going to tell us about some recent case law.
So the Court of Appeal in July of 2020 issued a new case called Marriage of Hine. And in that case, the depreciation deductions claimed by a self-employed father in his corporate tax returns on business assets were determined. The court found that he should have included those amounts. He shouldn't have deducted those amounts in calculating his gross income for purposes of calculating child support. As a matter of first impression, considerations of public policy and fairness favored reallocation to the father of the burden of proving correctness of corporate tax returns with respect to income and expenditures for purposes of child support. I would just like to note that the father, or the husband in this case, has filed a petition for review with the California Supreme Court, which as of 2 or so days ago when I last checked, it had not been granted yet. So this case may be questioned at a later date. In Hine, the mother contends that the trial court did not properly determine the father's annual gross income under Family Code Section 4058, and thus erred in calculating the amount of child support owed. After the trial court issued its decision, the Court of Appeal decided the question of statutory construction involving depreciation in intermarriage of Rodriguez. In Rodriguez, the court held that a self-employed parent's depreciation deductions for motor vehicles did not constitute expenditures required for the operation of the business for purposes of Section 4058, Subdivision A2. The court now extends the statutory interpretation for motor vehicles to depreciation deductions for equipment and other assets used in the self-employed parent's businesses. The court explained that the term expenditure describes an actual outlay of cash. The court held that claiming a depreciation deduction on an income tax return does not require an outlay of cash and thus does not reduce the funds available for child support. The court also held that the burden of proving that the expenses claimed on the tax returns constitute expenditures required for the operation of the businesses is properly allocated to the self-employed parent who controls the corporations. So if you have the party who is seeking a modification based upon increased expenditures for any purpose, then you bear the burden of demonstrating to the court that those expenditures were reasonably necessary to deduct them from your income. I think that this is something that JV as an accountant will probably tell you it's common sense, but I think sometimes for our clients, they just file their paperwork and say, these are the expenses. But I think as practitioners, we should consider whether or not we include additional detail in our clients' declarations as to what the expenditures were and why they were reasonably necessary, and why they shouldn't be pictured or considered as part of their income picture because they were necessary to continue operating the business. On the other side, if you're representing the outspouse who is not in the business, doesn't know what's going on there, you may want to conduct some discovery on this issue and determine whether or not these expenses were actually necessary, or if the other side is trying to decrease their cash flow in order to decrease their support obligation. So I think there are a lot of factors to consider both on presentation in an RFO and also on conducting discovery.
So let's talk about, in this COVID era, how we're going to either reinstate prior orders that have already been entered, or how are we going to make new orders. So initially we considered factors that need to be addressed when entering into a settlement or into a different temporary agreement. And maybe anticipating what the change of circumstances might be as part of any kind of an agreement that's entered into, in a way to limit the number of times that any specific issue, in particular support, needs to be addressed. So first, is or are the orders made as a result of the pandemic, are they intended to be permanent or temporary? Second, what are the criteria for making the orders permanent or temporary? Is there going to be an automatic adjustment if some triggering event occurs? And the pandemic, at least for now, is going to be treated as a temporary circumstance and will not be considered as a change of circumstance for permanent modification of child and or spousal support. So when going back to the question about what triggers a change relative to modifying existing orders, a return to pre-COVID income levels would be considered a change or a triggering event. A return to pre-COVID expense levels. For example, with so many people working from home, their childcare expenses are significantly decreased. But when everyone starts returning to work or working in brick and mortar settings, their childcare expenses are going to increase substantially. A return to pre-COVID employment levels may be considered a triggering event. And of course, a change in circumstances. So, oh, sorry, Sarah.
Okay. When you are representing the out spouse, something that you have to look out for with any support modifications over time is kind of the accelerated downward trend of support and the kind of whittling down of permanent spousal support. A lot of clients are expressing concern about, you know, their support being decreased. Maybe they're receiving support for a period of years because that was what they agreed to in the judgment, and they're concerned that if it gets whittled down now, then they're going to be looking at a termination date that's much earlier than they may be financially planned for or expected to be able to return to the workforce within. So something that you can consider discussing with the other side if you're able to settle your support modification matter is that you might want to ask that the adjustment be made without prejudice and not considered for future support modifications. You know, that's something that you can look at as maybe a potential bargaining chip and agreeing to a stipulated order and maybe giving the other side relief at an earlier date than they would otherwise receive in court. And another factor to consider in cases that have not yet gone to court and maybe just, you know, in the early stages filing for dissolution now is you have to consider what impact, if any, COVID has had on the marital standard of living. Usually when looking at the marital standard of living, people look at the last 2 years of the marriage. Well, here we are probably 6 months at least into 2020, where people's living expenses have been very different. They maybe didn't spend the summer traveling. They didn't, you know, make the kind of expenditures that they typically make during marriage. So you may want to consider seeking to use an expanded time period in a determination of the marital standard of living due to COVID-related changes. Another side of the coin to consider is that maybe the other side has a decreased need for support because of the decreased marital standard of living. You know, in filling out your client's income and expense declarations, I think it's important to make sure that they're done accurately and that you're asking your clients about any reductions in travel, reductions in household help, you know, a decrease in eating out and spending on entertainment, and a decrease maybe in some personal care expenses. But then there are also increased expenses that many people who we typically work with might have. So a lot of people who send their children typically to private schools or even public schools may be incurring additional educational related expenses for their minor children during this time period by hiring private tutors or pod teachers to come to their home and kind of facilitate distance learning and that type of thing. Also, given the, the changes in childcare, they may have decided to get a full-time nanny or someone of that sort instead of using just aftercare at their child's school. Also, household supplies and grocery expenses may have increased, as have some home entertainment and streaming and video game options. So just something to look at.
So here we have a lot of questions. Here are some possible solutions to some of the circumstances that we've described up till now. Possible solutions would include a percentage of income decline approach. So if you're able to determine that there's a specific drop that can be specifically ascertained, one possible way would be to agree that based on whatever that determined decrease in income is, will be applied accordingly to the support, which would temporarily drop the same corresponding percentage. For example, if revenues and sales or someone's salary drops 20%, then the support will drop 20%. If revenue, sales, or salary returns to pre-COVID levels, then the support will then return to the pre-COVID levels. And quite frankly, if it's a material difference, we could build in a true-up if necessary and if applicable. Next, we have the deferral of support approach. This is borrowing from banks and rent payments. It's possible to defer unpaid or underpaid support to a later date, as long as it's understood that the deferred unpaid support is going to be paid in full at a later point in time. So what does that mean in terms of when is it going to be paid? The repayment terms can be flexible and must be tailored to fit the situation. And then the other piece of that would be, is the duration of payments going to be extended? For example, if you have a permanent spousal support order that's supposed to terminate or be reduced to zero, then perhaps they would want to extend the duration of the payment so that the payor spouse would be able to catch up. Another approach would be the use of savings approach. The parties can agree that they'll make a preliminary community property distribution without prejudice as a bridge to get past the pandemic period. But this also is meant to not allow for there being any reimbursement or charge relating to the support issue, since each side will be getting that same preliminary community property distribution of assets. This will probably affect property division depending on what assets the parties have and how they are to be divided. For example, if they're depleting their liquid assets, then there's going to be an issue about how the illiquid assets are going to be divided. Next slide, please. No, one back, sorry, there. Okay, thank you. So separate and apart from the deferral solution that I mentioned earlier, you can place a pause on the support period. And if you place a pause on it, that really is in conjunction perhaps with the community property preliminary distribution, because the expectation is that the previously ordered support payments will resume as opposed to being deferred once the pandemic effect passes. And as a practical matter, where you have intact families, they're using their savings to get past this difficult time as well. One other possibility where you might have one party that has separate property assets that are more liquid than the community property, for example, which might own a house or other illiquid assets. The party with the separate property can use their funds, the liquidity, to pay for family expenses during the pending dissolution, depending on the date of separation, And while one might argue under C versus C that it could be construed as a gift to the community, you're going to want to specifically agree that the separate property funds being used during this time and being paid on behalf of the community will be subject to reimbursement and or a reallocation of community property at the time that the property is going to be divided. And again, practically speaking, intact families without savings would be incurring debt to get through financial hardships. So rather than incurring debt, the use of the separate property liquid assets is not far different from incurring the debt that the community might have to absorb. One other possibility, oh, I'm sorry.
That's fine, Your Honor.
I wanted to say, I'm sorry, I wanted to make one more comment. We've been trying to be creative in terms of leveling what support payments are being paid now since there's significantly reduced income. And one of the things that we've been doing is essentially paying in advance on any Osler-Smith payments that may be due in the future. So for example, if you pay support in the amount of $5,000, but the real amount is only $4,000, that extra $1,000 that's being paid is expected to and will be treated as an advance payment on any Osler-Smith payments. I found that it's more palatable, if you will, because the payor spouse understands that it's not a situation where they won't get that money back, that there's a place for it to be repaid by the supported spouse.
So another solution, which is, we view as, the more traditional, would be to agree to a reduced base support and implement a Smith-Osler percentage for any possible future income and income returns. Now, this is more traditional. I think we're all familiar with how to do, at least us as forensic accountants, and are very familiar with how to implement a Smith-Osler percentage. It's familiar to most family law practitioners. We can interpret it at a later date, and it's easy for us to verify at a later date. Smith-Osler percentage is what we traditionally use when we don't know what the income is going to be. And certainly in these times, what the income is can be uncertain. So some, Smith-Osler can get very complicated in certain situations. I know for me, I try to simplify it as much as possible. What I'm referring to is the use of the bonus tables within a DISO master program, and we assume that our audience is familiar and knows how to use that, at least on the face level. When you get into a two-earner situation, it can get complicated. Then when you are doing this approach to the Smith-Osler in the future, it's important to kind of create a mechanism, have a process for ongoing discovery situations. Because what's going to happen is this approach we're suggesting is going to be a true-up at some routine level, annually or whatnot. And you want to make sure that the income that it's based on is comparable and consistent through the prior periods.
So in drafting, whether it's a stipulated order or if you're filing an RFO, I think it's important to request from the court or draft in your stipulated order very clear findings as to what the current level of support that you're agreeing upon is based upon, so that if there is a future modification, it's very easy for you and your client to determine whether or not there is truly a change in circumstances. I think a lot of times practitioners will be quick to settle a case and cut a deal, and they won't include those findings in some of their orders, which is really problematic, 6 years down the line when you're trying to find an income and expense declaration from 6 years ago that you think was exchanged around the time that the stipulation was entered. So it's really important to make sure, especially given kind of this uncertain economic time we're living in and the high likelihood of future modifications, that your order has clear findings. I also would urge you to consider including additional clear language regarding the timing for exchange of financials to determine an Osler-Smith amount and when that payment will be due. You should include an agreed upon list of financials to be exchanged, whether that's general ledgers, tax returns. Do you want to include supporting bank statements in that request so that your client and the other side doesn't have to go through the expense of formal discovery? It's already clearly laid out in the order who's supposed to provide what by when, and when the Osler-Smith payment then will become due. I think it's a good kind of rule of thumb to maybe make your exchange of information due about 30 days after tax returns are completed for the business or after the end of the fiscal year. And then I also think you should consider whether or not you want to include a provision as to the costs of a dispute between the parties if you want to agree in advance that they have to attempt to mediate any dispute on an Osler-Smith prior to filing an RFO. Those are all things that we can kind of consider building into our orders to make things a little bit easier for us down the road, because I think a lot of people right now are reducing their base support obligations and then sticking a Smith-Osler on the back end. But when you comes time to calculate that amount, people like JB are going to say, hey, I don't have the records I need to actually figure this out. And, then that puts you in a position of incurring expense on behalf of your client filing an RFO so that you can conduct discovery. And, sometimes given the magnitude of the potential Osler-Smith, it really doesn't make economic sense for clients to do that. So just something to consider in drafting these types of orders. And, I think if you have the client who is the earner in this situation, I think the way you can kind of sell it to them is say, look, you're going to incur a lot of expense responding to discovery and potentially having them file a motion. Let's agree in advance what you're comfortable providing and, make sure that we avoid some of this expense for you later on so that, you don't get into a situation where the other side is constantly, asking for more records and more documents. And, it kind of puts you in a bad position as the person representing the earner because, at a certain point, informal discovery can become very expensive. So you have to kind of weigh, whether you want to look unreasonable to a judicial officer or just kind of kowtow to the other side's demands. I think these are all kind of arguments that you can avoid by being clear in drafting your orders.
So we all would like to thank you for attending and listening to us today. As you can see, creativity is going to be key to resolving your cases. And practically speaking, based on my experience, I'm finding that the creative solutions are key to getting our cases resolved. Thank you.
Thank you, everyone.
Thank you so much to Sarah and JB and Judge Goetz. We really appreciate all your time and hard work in putting together this information for us. Our next panel, I'm happy to introduce, will be Peter Walzer and Christina Djordjevich of Walzer Melcher and Alexandra Peais of Gursey Schneider.
Good morning, everybody. Let me share my screen so you can see what we're talking about. Can everybody see asset valuation issues during hard times? You can? Great.
Good morning, everyone. So we're going to be discussing business valuation fundamentals and specific things to consider during tough economic times such as COVID. So obviously, as we know, And we've probably heard in many webinars before this one, these are unprecedented times. COVID has caused disruptions that nobody could have predicted. It's lasted months at this point, and we're not sure how much longer it's going to last. We hope and we say that things will get back to normal maybe once there's a vaccine, but one, nobody knows when that's going to be, and two, it's not like a magic switch gets flipped at that time. This all can go on for a lot longer. I read a report by McKinsey the other day that said that COVID-19 recovery in the hardest hit sectors could potentially take more than 5 years. So we may be in this for the long haul, and given the current economic volatility and the hardships that many businesses are facing, given that it could go on for a while, we as family law practitioners really need to be prepared and equipped to analyze these issues and the impact on our clients' cases and assets. So, what types of assets are potentially impacted by COVID in this, and in general, in hard times in general, but specifically COVID? First are stocks. So as we know, the stock market is highly volatile, and things were looking good at the beginning of this year. Everything plummeted in March or April of this year. Things have bounced back in recent months. So generally dividing at least publicly traded stocks in kind, even in good times, is probably the best approach. But it's particularly important now during periods of such high volatility to avoid a windfall to one party. The second category is real estate. And the impact of COVID on a piece of real estate may depend on whether it's commercial or residential, and also where it is geographically located. So for example, metropolitan areas such as San Francisco, New York City, where living spaces are small, have been very hard hit and prices are down. On the other hand, residential real estate in other areas is doing very well as people reassess lifestyles, want homes with more space. In LA, I don't think there's been much of an impact. I think also there's an issue of people not paying mortgages. People who have suffered economic issues aren't paying mortgages, and what impact is that going to have on the housing market long term? I think commercial real estate in general is sort of more consistently doing pretty badly, and the values are low as people shift to a longer term work from home situation. Third, of course, businesses are an asset class that is definitely impacted by COVID. COVID has caused hardship to businesses businesses both large and small across many different sectors. I read a statistic that actually up to 40%, even more than what the slide says, up to 40% of small businesses may close by Q4. And as we all know, small businesses are very frequently valued in divorce cases, and these are often some of the most litigated issues in divorce cases. So this is the area that we are going to focus on the most in our presentation today. So this slide lists, and I think the last presentation went through this as well, but this slide lists a few of the industries that have been the most hard hit due to COVID. And of course, it's the travel industry, airlines, hotels, etc., food service industry. We all know that restaurants and bars have been very hard hit. Educational services. Mining, oil and gas, as people drive less, people are traveling less, people are staying home. Of course, the arts, entertainment, and recreation, such as gyms, movie theaters, sports, TV, movie production, and retail, at least the brick and mortar retail. Of course, some industries are doing quite well, exceptionally well during COVID. As in any economic crisis, some industries do better than others. Examples are food delivery services, grocery stores, household goods stores, Amazon, other online retailers, maybe liquor stores too, I think are doing well. So when we have cases that involve a business impacted by COVID or another economic hardship, how do we account for and consider that hardship in the business valuation, practically speaking?
And this is what the core of our program today is really about. We're trying to look at solutions to the problems. There's no one solution, and we're all going to be weighing on it. I don't know if we introduced ourselves. I'm Peter Walzer, Walzer Melcher, and Christina Djordjevich is my partner. And Alex Peais is with Gursey, Schneider in San Francisco, and she's an accountant we work regularly with on our cases. So we're excited to have her expertise. And we're going to be looking at it from both the lawyer's point of view and the accountant's point of view, and how we deal with extremely difficult issues. There is some precedent with the prior depression in 2008 and how we dealt with that, but this is much more extreme and could have much more long-term effects. So yeah, Chrissy, go ahead.
So Alex is going to go into this in more detail, but some initial questions in terms of how to account for hardship in a business valuation. One, can we give more or less weight to historical earnings in a given recent year in the valuation? And the answer is, of course, yes. This is routinely done in business valuations. If a particular year's earnings are an outlier, they would be given less weight. If the performance is expected to recur, perhaps it would be given more weight. So depending on how hard hit a business is, that will impact what years to give weight to. Can we include interim financial statements in the analysis? The answer is yes. So this would be relevant, for example, if financial statements available complete financial statements went up until the time before the impact of COVID was really felt by the business. Can you look to interim financial statements? Yes, and you should, and certainly the in-spouse will be arguing that those should be taken into consideration, notwithstanding that it's not a complete year.
And those may be very tricky to get because, as you know, getting documents is tough, and getting out records like this that are really current are tough, and you may need to bring in your personal accountant to testify on this, in addition to the forensic accountant, how they were prepared, the methodology, and so forth, because there will not be tax returns for probably a year and a half. So you'll have to rely on these records that are generated almost concurrent with this event.
And additionally, it's not, we'll talk a little bit later in the presentation, not just records, but of course, the evaluator will need to speak with the folks at the business to find out what's going on that may not be reflected in the financial statements yet. Something that's maybe just started happening, projected to happen, and have a credible basis for arguing why that is. Third, one question we've been discussing is, would we be able to adjust the risk assumptions that are part of the build-up method used to determine the discount rate? So we will kind of break that question down throughout this presentation. The build-up method is used in income-based valuation approaches to determine the capitalization, to determine the discount rate, and then the discount rate less the long-term growth rate was what determines the capitalization rate. And the build-up method includes some risk factors that can be adjusted. So Peter and I thought, well, can we adjust some of those risk assumptions to account for COVID? And the answer is probably not. We'll go.
Now, I'm going to take the opposite position, and Alex and I are going to have a little argument. Spoiler alert, I'm probably going to lose, but that's what's going to come up later on. Exciting discussion about the build-up method, so don't go away.
My primary comment for why it might be inappropriate to adjust the discount rate in determining the impact of COVID is because the discount rate or capitalization rate assumes the risk is going into perpetuity. So if we think that the impact of COVID might be a shorter term issue, then it would be more appropriate to adjust the earnings that you are either discounting or capitalizing to account for the short term nature or loss of profits for the business rather than assuming that that impact will go into perpetuity.
Well, we'll dial down on that later. Chrissy, can I move the slide forward for Alex?
The last thing I'll say before we move forward is just basically high level. The key for the business valuation is to take an approach that addresses the economic hardship, because you can't just ignore it, but that at the same time does not give it 100% weight and say, okay, just because this business may be having a tough year right now, there's a super low value because there's the risk that one spouse in that case will get a windfall if the hardship doesn't continue. So with that, I will turn it to Alex to discuss some business valuation fundamentals.
Thank you. So I'm sure that most of you have heard a lot about different approaches or methodologies for valuing a business. A lot of times people don't have a discussion about the premise of value for business valuation, and many of you might not even know what that means. And that's because in a normal family law setting, we are valuing the business in what's referred to as a going concern premise of valuation, which just means that we're assuming the business is going to continue operations. But during COVID and during any economic downturn, but especially right now, that might not be the case. As Chrissy said a couple of slides back, many small businesses are closing. And so you don't want to value the business as a going concern if it's going to have to discontinue operations or be sold. So if you're operating in an in-exchange premise of value, there are a few different ones that have to be considered. One is an orderly disposition, and another is a forced liquidation. And what is the difference between those two? Essentially, the main differential between those two is whether or not the sellers have the time and resources to evaluate and attract the best offers, or whether they're in more of a fire sale type of scenario where they really have to liquidate the business, sooner than later, and maybe not get the best price for it. So one more thing to say about if the business is going to discontinue operations, clearly in that type of situation, it's better to just divide in kind the proceeds from the liquidation rather than to try to have your business valuation expert value what the business is worth based on discontinued operations and awarding it to one spouse.
So would you bring in other experts or consult with other people if you had to do a liquidation value analysis, for example? Go ahead.
Yeah, I would say yes. A lot of it would be to determine, what inventory would be able to sell for. But I would just suggest in general that if the business is going to be liquidated, it's easier and more fair to both sides to just split the proceeds equally. Whatever you get, and that ensures that one spouse is not taking an asset that might be valued at too high or too low, and you can just divide the proceeds equally.
And do you envision an auction process for this type of liquidation?
I think it would probably depend on the industry that you're in. I haven't personally dealt with very many forced liquidations or orderly dispositions in the family law context. Usually we're valuing a going concern, but I would assume that in some industries, an auction type, sale process might be warranted.
So it seems like to me that you'd want to have this before the court initially, whether there was even going to be a valuation and whether the company would be liquidated, and maybe ask for a bifurcation on this issue rather than try and argue the business is not going to exist in the capitalization rate argument or at some other place in the valuation process.
Yes, and hopefully, if the spouses are, being logical about it, like for example, a really hard hit restaurant where they might not have the ability to continue going until COVID is over and they can bounce back, then maybe the parties can stipulate, maybe not.
Alex, that's not very realistic. That doesn't happen in our cases.
I think it would be appropriate to have that issue bifurcated, and also potentially to have an expert in that particular industry be the person to talk about whether it would be an orderly disposition or forced liquidation and what that process might look like, rather than just, a generic business valuator.
So what about the different approaches to business evaluation and how they're used in the COVID situation?
Okay, so assuming that you are valuing a going concern, meaning a business that's going to continue operations, there are 3 types of approaches, and there are different methodologies under each one of these approaches for valuing the business based on what makes the most sense for the subject company that you're looking at. Today, we're going to spend the most time on the income approach, and we're going to look at a couple of different methodologies underneath that, but I'll just briefly touch upon the other 2. A market approach is where you look to transactions involving similar or identical businesses. Clearly, there can't ever be identical businesses, but that's literally in the definition of market approach. Similar or identical businesses to try to determine the value of your business. So you look at kind of the prices of sales of similar businesses to try to determine the value of the subject interest that you're looking at. Peter and I had a discussion yesterday about this. This approach is not widely used in California family law setting because it's very difficult to find a truly comparable business. And so, it's better to use this approach as more of a sanity check for other approaches that you might be looking at. So you might look at an income approach and an asset approach and just use the asset approach as kind of a sanity check to see whether your income approach valuation is in line with businesses that have been sold recently.
Take a look at Marriage of Honer, Honer, 2015 case that talks about an expert that used the income approach, but also looked at price earnings ratios. But before Honer, that was not a way to go according to Marriage of Lotz, L-O-T-Z, and Hewitson. But Honer sort of opens the door for an expert to at least look at price earnings ratios in this context. So they're not absolutely forbidden anymore.
Yes, and like I said, you can do the exercise. It's probably good to do the exercise because there is available information to do this, but you might weight this approach differently, much lower, or not weight it at all, but you could include your findings just to show that your other approach valuations are in line with other companies that have been sold in the same type of industry. Then an asset approach, we'll just very briefly touch on this. That is appropriate to use in instances where the value of the business is primarily derived from the underlying assets that the business holds. So an example of this might be a real estate holding company where the holding company itself just owns a piece of rental real estate, and the underlying value of the real estate, including its rental cash flows, which would be incorporated into a traditional real estate appraisal, dictates the value of the holding company.
And I see a lot of arguments on this where, we're representing a person that might own shopping centers and they want to have it valued with an asset approach. Why? Because they don't want the income stream to be valued. They don't want goodwill attributed to their company. So the outspouse in that case may be arguing more of an income approach, and the inspouse may be arguing a market approach. An asset approach. Yeah, all of these you got to look at and say, what is the best way to portray it for my client? I just want to go back to the market approach. When you're talking about a small business, often you'll look at buy-sell agreements that are arm's length or buyout or buy-in of partners to indicate value. Is that sort of a market approach when dealing with professional corporations or that kind of thing, Alex?
The market approach is really, yes, it can be. And in those instances, you absolutely would want to look at that information. So when I was saying the market approach is not favored, that's when you're looking at other companies like guideline public companies or mergers and acquisitions of private companies that have available information online, because there aren't any truly comparable companies. But if there have been prior sales or partial sales of the actual subject company that you're valuing, of course, you would absolutely want to get information which would help you to determine, the valuation expert to determine the value of the business. It might not be the current value of the business, but the expert should absolutely look at that historical information in determining the value. Lastly, the income approach, which we'll go more into, that is appropriate to use when the value of the business is primarily derivative from its cash flows. So if you're using an income-based approach, there are different methodologies that you can use within that approach. We're going to talk about two of them today, the capitalized cash flow method and the discounted cash flow method. I will say there's a third method that I'm sure a lot of you have heard of. That is the excess earnings method, which is generally used in valuing professional practices like a lawyer or a dentist or a doctor. For purposes of our discussion today, it is similar to a capitalized cash flow method in which you're looking at historical earnings of a company. So whatever we are discussing today with respect to the capitalized cash flow method can also be used and should be addressed in an excess earnings method if you're using that method.
And one of the questions I asked Alex is whether the build-up method, which we're building up to, is used in all three methods, the capitalized cash flow, the discounted cash flow, and the excess earnings approach. And her answer was?
Yes.
Yes.
The build-up method for determining the discount rate. Yes, it is used for all three. There are other methods for determining the cap rate, but build-up method is most commonly used for all three. So when you're looking at a capitalized cash flow method, the main thing you're looking at are the historical earnings of a company over a representative period of time as a predictor of the future value and earnings stream of the company. So what does a representative period of time mean, and can different people have different ideas of that? The answer is absolutely yes. And I think that during COVID, people will have very different opinions about what a representative time period looks like. And this might cause two different business valuation experts to come up with even more discrepancies between their values due to how to address the issue of COVID and how it impacts a business. The good news is that you can weight years differently when you're looking at the historical earnings to achieve results that best reflect the projected future earnings of a company. So like Chrissy kind of talked about earlier, if a business, let's say, was growing at a sustainable growth rate of about 3% a year before COVID, and then we have COVID hitting and we see it drop a couple of percentages or even have negative growth this year, we can certainly weight this year as less representative and give it lower weight than prior years where there was a consistent, long-term growth rate of about 3%, so that we do capture the impact of COVID. We can't completely ignore it, but we're not giving it as much weight because it might not be representative of the future cash flows of the company, which is really what you're trying to value.
You want me to go back? Sorry.
Yeah, sorry. This method is most appropriate to use when the earnings of the company have stabilized. So it's not the best method to use if the earnings of the company are expected to, oscillate in the near future. It's really supposed to be used when the company is mature and its earnings have stabilized to a long-term sustainable growth rate.
And so that gets us into the next method, which is, for whatever reason, a little bit, it's not used as much in California as Alex will tell you, but in a program I saw last week, Jared Tonks and Lena Hindekar argued for this method. Gutsy move on their part, but something that you might want to consider as a backup because it may be more realistic. Why is that, Alex?
So the discounted cash flow method basically uses projected future earnings as a basis for the business value. And it's appropriate to use this method when the earnings of the company haven't yet stabilized and there is expected to be variations in the earnings in the short term before the company can stabilize at a long-term sustainable growth rate. So you more often than not see this in the context of a company that is growing more rapidly than the long-term expected stabilized sustainable growth. But for example, a startup valuation, I'm in San Francisco, so there's a lot of Silicon Valley businesses. The short-term growth might be, or the short-term earnings of a company might be negative or zero, and the long-term stabilized sustainable growth might be higher than current. It can also be used to capture the short-term economic impact of COVID, where the short-term growth is also expected to be lower than the long-term sustainable stabilized growth.
More discounted cash flow?
Yes, so this is like Peter alluded to, it is not favored in California for several reasons. You're using projected future earnings of a company to value the business, which is seemingly contrary to Family Law Code Section 771A, which states that the earnings and accumulations of a spouse post-separation should be their separate property. It's also somewhat speculative in nature, but business valuation in general is somewhat speculative, regardless of which approach you are using and methodology you're using. And, you know, as we just discussed a little bit, it's basically the same, the math is a little bit different, but it's basically the same fundamental idea of the capitalized cash flow method. The only difference being you use the capitalized cash flow method when the earnings of the company have stabilized and the long-term growth rate is expected to be sustainable. And you use the discounted cash flow method when there may be some interim oscillations in the business income and it hasn't yet stabilized. So it's the same type of evaluation. It's just, has the company, you know, is it reached maturity and has the long-term growth rate been achieved? And, you know, one interesting thing that I was thinking about as it relates to using the discounted cash flow method is, and as it relates to the contrariness of it to Family Code Section 771A, is what type of business is it? If it's like a widget manufacturing company, or it is a very capital intensive business and it's more of a reverse Van Camp type of environment where the increase in value of the business is not primarily due to the owner operator spouse's efforts, then I don't understand why the community shouldn't share in that future value and be, you know, have that value be captured in a discounted cash flow method when the owner operator spouse is not responsible for potentially the short-term growth in excess of the long-term sustainable growth. And the kind of flip side to that is, you know, during COVID-19, the person who's keeping the business, the owner operator spouse, doesn't want to buy out their other spouse's interest based on historical cash flows that might not fully capture the economic impact of the pandemic. So the discounted cash flow method can be used to, you know, account for the short-term potential negative impact of COVID in the valuation that you come up with.
So I love this stuff, and it is really advanced. If you're having a hard time with it, feel free to call us to discuss it. But I've always heard about reverse Pereiras in business valuation, which basically says the efforts of the owner should not be included. I've never heard the term before Alex introduced it, reverse Van Camp environment. And that's super sophisticated and really is an argument for the discounted cash flow method and gets around Family Code 771 that says earnings of a spouse after the date of separation are separate property and shouldn't be considered. If you're ever down deep in these woods of post-separation efforts, reverse Van Camps, you really got to talk to your expert about it. And it may be really more appropriate in this and relevant in this COVID, post-COVID environment to discuss it. So you really have to understand capital intensive, which is Van Camp, which generally favors the separatizer, and Pereira issues, which favors the community. So really want to look at these issues and understand them. And if you're not getting it the first time, don't worry, we'll help you out. So let's go on to the core of every business evaluation, the build-up rate. It's a method of determining the discount rate. What is the discount rate, Alex? I know I didn't prep you on this, but I'm sure you can tell us.
So once you come up with a representative earnings stream, you either are projecting that into the future and discounting it back to present value based on certain assumptions of risk, or if you're looking at a capitalization of earnings model, you're looking at the current, the current representative cash flows, and you're capitalizing that forward based on different risk factors. It's basically determining the risk in the business valuation.
So I'm going to give you a Peter Walzer answer, which is different than an Alex answer, is there are two numbers you can multiply the earnings of a company from to get the valuation of that company. One is just a number, 1, 2, 3, 4, 5. It's a multiple, and it's the basically the opposite or the reverse of a capitalization rate. They're generally the same thing. Capitalization rate is expressed in a percentage, 20%, 30%, and you divide that by the earnings by that percentage rate. They're basically the same thing. They're just expressed differently, often in an excess earnings. You'll have a multiple of 2, 3, 4, and sometimes you'll get a 1. 1 times earnings will be the valuation of the company. That's how I look at it. It's pretty simple, but how do you get that number? Let's say you pick a multiple of 3. How do you pick 3 as opposed to anything else? I mean, sometimes you'll hear a rule of thumb. It's always a 3 or always a 1. Well, we know you can't use rules of thumb in California. So you have to support your argument for the build-up method to come up with a 3 or a 2 or a 4. Any more that can be said on that before we get to the chart, Alex?
Yeah, the only thing I'll say is just I'll say what a discount rate or a capitalization rate is the inverse of the multiples. So
That's right. That's the word I was looking for. I said opposite. It's an inverse.
correct.
Okay. So this is a chart that we added to the slides, but you can just Google build-up method and you'll get this chart. And basically, you build up. I never understood why this worked mathematically, but this will give you your multiple or your capitalization rate. Is that right, Alex? Did I say that correctly?
Yeah, it'll give you your discount rate, your capitalization rate, and the inverse of that will be the multiple.
Right.
Yeah.
But essentially, you use this method. Now, starting with number 1, risk-free long-term U.S. bond rate. Where do you get that from?
It's from online resources. A lot of these that you'll go through are from Duff and Phelps, but there are different resources that you can use to get these.
So you can get Duff and Phelps book, probably best to get it from eBay or Craigslist, just to get an idea. It used to be called Ibbotson. It's a great book to read, and it will show you the formulas. I gave it to Chrissy to read on the first day she came to work here. She's about 10 pages through it. It's pretty tough reading, but this is published material. What does this rate run now, Alex, if you know, about 2.5 or something like that?
Yeah, probably. I haven't looked recently for COVID, but yes, I would assume it's a little bit lower right now.
So then the equity risk premium. So you get, let's say you take, we'd say, let's use 3 for a number just to make it easy. What would the equity risk premium rate be? Is that also published in Duff and Phelps?
All published in Duff and Phelps, yes.
And what does that run? More like a 4 or 5?
You know what? I have to go look.
Putting her on the spot, forget that. And then the size premium, let's say that's 3. So you've added 3, 4, and 3. And then the industry premium. So if you're in the travel industry, has that changed for COVID, or does that still remain constant?
So the problem, and we kind of touched a little bit upon this, Peter, all of these are based on published data. And so the impact of COVID has not yet really been accounted for in this published data that the business valuation expert would use to come up with these numbers, and probably will not be available for years to come, because after a year ends, it still takes a little bit of time for the book to be published for the prior year. So really, when you're adjusting for the impact of COVID, the only thing that we have available to us right now is to adjust the cash flows rather than adjusting the capitalization rate or discount rate. And like I kind of touched upon earlier, it makes more sense to adjust the cash flows rather than the discount rate or capitalization rate, because that assumes that this risk will go into perpetuity, the impact of COVID. So unfortunately, we won't have a Duff and Phelps published data that includes COVID, COVID impact for many years to come.
So then we have the company-specific risk premium. And some people argue that that should be adjusted. Let's say in your doing a valuation of an airline company, which we had a small airline that we valued in a divorce. We've talked about adjusting that, but Alex said that would not be the proper way to do it. But I'm telling you, some people will be doing that.
Yes, and I think, so the company specific risk premium is the only one that's not published, right? So that's very, very, very in the eye of the beholder, and different valuation experts will come up with different numbers. And some might say that that is a very subjective number that's very difficult to explain because there's no data underlying it. It's just kind of based on your experience. I do agree with Peter that if you're in an industry that will likely have very long-term impacts, then potentially this might be something to look into. The problem is, from the expert's point of view, you want to be able to support your position to a judge based on, published criteria. And this is not where you can support your position. So you're basically it's very speculative, and there's not any, data to support what the long-term impact of COVID will be on the airline industry. And, potentially all of us are so cooped up right now. I know I can't wait to go on vacation as soon as we have a vaccine. I'm going to be flying all over the world and getting in my vacations that I missed over the last several months. So it is really difficult to predict that. And so I would say that the evaluator needs to be very careful if you're going to try to adjust for it in the company specific risk premium.
So one of the experts who's published many books is Jim Hitchner, and last year he did a program. It was a tongue-in-cheek title to get interest, and it got my interest, was how to rig a business valuation. And he focused on the company-specific risk premium, and that's what you want to look at, whether you're doing a cross-examination or you're looking at your own expert, because there's a certain range that is within the range of makes sense. And he did an analysis of what experts in the business valuation industry are using, and he came up with a number that made sense. But if it varies from that, you can get an idea that the report is, quote, rigged. And so you just want to watch this number and see what the expert is doing, and is it within the range? And your expert will tell you if it's in the same. So then you get the after net cash flow discount rate represented by a percentage. And then what do you do with the growth rate, and how does that factor into the business valuation, Alex?
So if you are using a capitalization of earnings model, which is taking the current representative cash flow based on historical earnings, then you need to subtract the long-term growth rate to get to your capitalization rate. And the long-term growth rate, it's used around 3% right now if you were going to just estimate. And it's the long-term sustainable growth rate to come up with your capitalization rate. However, if you are doing a discounted cash flow model, because you're projecting into the future, the growth is already inherent in your cash flow projections. So you just use the discount rate to present value.
So great. So the number after all of this is going to be somewhere in the 15 to 30% range, probably. Is that what it looks like?
Yes, I would say that's generally kind of the range you're going to be in. There are some instances where the rate might be higher if the business is specifically, if there are some, very specific company risk. And I'll give an example. If there is a company that is a consulting company where 90% of their revenue is with one client, that's a lot more risky than if the revenue is spread out over multiple clients, because if they lose that one client, then automatically overnight, 90% of their revenue is gone. So in those types of scenarios, you really have to understand the specific company, and it's, the evaluator's job to discuss that with management and identify some of these things to see whether there might be more or less risk than a normal business in that particular industry.
Thank you. So what should the expert consider in terms of the risk factors, business hardship, and You know, it's pretty obvious they're going to look at, you know, have stores and facilities closed. I mean, it's obviously in the restaurant world, yeah, I understand very big chains have been closing around the country. Decreased traffic, customer loss, and there's going to be argument whether it's permanent. Right now, it's very hard to tell. We don't have a vaccine. We don't know how long this is going to last. I mean, we're not making, in the organizations I'm involved in, we're not planning on any travel in 2021, maybe tentatively in the fall, but even that's not looking good. Production delays, all the requirements of COVID, things aren't getting produced as fast. I'm sure, you know, that's pretty intuitive. You know, you can't get bleach. You know, you can't get certain products. Are you going to lose contracts? I mean, in the organizations, we've canceled our hotel contracts going out at least a year. And is the company nimble enough to adjust to the crisis? Do they have enough personnel? Can they work remotely? Can they, do they have the creativity to do other things? Do the laws allow them to adjust? I mean, a restaurant can only do so much. There's only so much outdoor seating, and it's freezing cold in most of the country. So what can they do? And how many people have they laid off? Hiring, firing is very detrimental to a business, and it takes a long time to hire people. It takes a long time to fire people, and there's a lot of liability involved in the termination of employees. So those are factors that you should be looking at. Also, you're going to be looking at the capital. Were there savings? Were they prepared for this event? You know, if you have savings, you can weather almost anything. If you're running at a very low margin, you really can't weather these things. And the business has a risk of bankruptcy or reorganization. And that goes to the step one in our presentation. That's what you have to evaluate. And you may want a hearing just on that issue, as we talked about. Also, you have loans, Paycheck Protection Program monies. You know, they say that's all going to be waived, but perhaps they had to lay off employees and it's not going to be waived, and it's a debt on the books of the company. So you're going to have to determine whether that is a factor. And what about alternative valuation dates? That's something that at the beginning of every business valuation case, you're going to say, is there another date for valuation we should pick? And since you may be having a trial next May, in the fall of next year, especially because of the COVID delays, you may want to argue a March date evaluation or an April date evaluation to take into account of COVID. Now, that's going to be a tough one, but yeah, go ahead. What do you think about that, Alex?
We kind of had a little discussion about this yesterday. It was interesting because if you know, a lot of people get confused on business valuation, but everyone's familiar with a family residence. So, you know, obviously right now, the family residence might be valued, if you're living in San Francisco, at way lower than it was valued a year ago. But you can't just, you know, as the person who's not keeping that property say, well, it was valued at $1 million more a year ago, so buy me out at that value. So, you know, an alternate valuation date, you definitely, if you're the person keeping the asset, you might want, in a business valuation context, you might really want to discuss how that is unfair, because you have to account for the current economic downturn in the value of any asset that you're dividing not equally between the parties. So, you know, I think it's really important in the business valuation context to account for the short-term impacts and, you know, make sure that it's as accurate as it can be, not projecting them into the perpetual future, but at least accounting for the current economic downturn.
And I'm not saying that's a remedy. I'm saying it's a consideration. I don't think it's a winner necessarily, but it is definitely something to look at in every case, COVID or no COVID.
Right.
So, Chrissy, what about timing here?
So what you can do about hardship and addressing hardship and evaluation really has to do with where the stage of the case is. So if you're at the beginning of the case, like when somebody's just filed, you're just getting, just getting everything started, you have the most flexibility in terms of you're going to have time to see how things play out with the business, making sure all the records that you want included in the valuation are included, having interviews with the business owner. I mean, or also like if you're an out spouse and you think, okay, things are really bad right now in the market. Hey, maybe I want to hold off on this altogether. If that's the party filing for divorce, maybe they want to hold off, see how things play out. Obviously, if you're at the end of the case, if you're close to trial, it may be too late to do much in terms of changing the valuation. Obviously, like I said earlier, the interim financial records and updated interviews and things like that can come into play, but you're kind of more stuck the later in the case that you are. And obviously, whether you represent the in-spouse or the out-spouse, you're going to have different strategic interests. The in-spouse wants a lower value, the out-spouse wants a higher value, and so how you kind of play things depends on who you represent.
And it's tricky. I remember in the recession, depression, 2008, representing out spouses, their whole life they'd planned to build up the business with their spouse, and then all of a sudden it's worth 50% less. And so their plans of the good life are, ruined because the timing of the divorce was unfortunate for them. So it's a very tough decision, and you can't delay a divorce indefinitely. Sometimes people drop the divorce and wait till things better times, but there may be worse times. Some businesses may not survive.
So we're going to talk about a different topic now, specifically about the possibility of continued co-ownership of the business, which is a temporary fix potentially. So to take a step back, there are basically three options for dealing with a business interest in a divorce, assuming the business does not need to immediately be shut down. And that's a buyout, a sale, or third, possibly co-ownership, continued co-ownership. So a buyout is really the preferred option because it's a clean break. It avoids the ex-spouses having to be in business together. But as we've discussed, a buyout, requires valuation and an equalization payment to the spouse being bought out. And value is uncertain during an economic crisis. And even if valuation is possible or agreed upon, there may not be enough money for an equalization payment to be made right now. So while buyout is really the best option, it's not always possible in the short term under these kind of circumstances. The second option would be to sell the business. But most business owners, unless their business is really in bad shape, they don't want to sell the business because they've put so much time and effort into it. And they want to see if they have that luxury, to see if things rebound. So, also in an uncertain market, it might be difficult to find a ready, willing, an able buyer to buy the business. So that leaves co-ownership as a potential default option. Again, not a preferred option and fraught with danger, but may be the only realistic option in the short term. And I say, hey, Peter, could you go back to the...
I'm sorry.
Okay, I say fraught with danger, but it is only a temporary measure until the business can be either valued or until cash is available to effectuate a buyout. And obviously, the reason that it's fraught with danger is, these people are getting divorced, there's a lack of trust, and they don't want to stay, quote unquote, wedded to each other, so to speak, in a business capacity, if they don't want to stay wedded to each other in a legal capacity. So it's important to stress, if you do pursue this option, to do your diligence about the business, get a corporate attorney involved so that you can structure the co-ownership agreement properly, knowing everything about the business, being able to, account for things going forward and consider all the relevant factors. Also, before we talk about the structures available, With a co-ownership situation, you'll need to determine the reasonable compensation of the owner, operator, spouse going forward, so that he or she will be, appropriately compensated for his or her post-separation efforts in operating the business. And any net profits over and above that reasonable compensation is what will be divided between the ex-spouses.
And I do want to say reasonable is not what you or I, or especially the owner operator, is going to think is reasonable. It's based on certain averages, what similarly situated people in that industry would be paid. So if your owner is making $1 million a year, their reasonable comp may be determined to be $400,000 a year. And they're not going to be happy making $400,000 a year and then splitting everything after that with the outspouse. So this is a very litigated issue. There are not a lot of experts that weigh in on comp like this, and you'll have a hard time finding them, and they may not say what you want them to say. Any comment on that, Alex?
Just that in very specific industries, I think it's really important to potentially have your own reasonable compensation expert, because there are nuances that, a business valuator just looking at a survey is not going to be able to testify to. So if you have, if your clients have the wherewithal to hire a more, targeted expert in this category, it might be worthwhile.
And just on this comp, most of them use a survey called Economic Resources Index, ERI, or
ERI.
And it's really as good as any other survey, which to me is not very good. And you can easily cross-examine somebody on that. But this is the go-to resource for the comp experts for pretty much everybody. And it's hard to argue against it, but it's not going to make your client happy if you're representing the owner. So you've got a situation where you're stuck. They're going to operate the business together. You can't give both of them control because they can't stand each other. What are you going to do, Chrissy?
Okay, so there are 3 possible ways that ex-spouses can co-own a business interest in terms of the structure. So this topic could be the subject of its own presentation. And in fact, my partner, Chris Melcher, and I gave a presentation on this topic, but we'll talk about this very briefly. So the 3 approaches are the in-kind approach, the holding company approach, and the nominee approach. So first, the in-kind approach is preferred. And with this approach, we would say, okay, there is currently one spouse who holds title to the business interest, and we want to split that business interest into 2 pieces, one for spouse 1 and one for spouse 2, and we might have a different class of equity for spouse 2, who has historically been the non-manager spouse with reduced or no voting or management rights.
And I've done a modified version of this recently where we had a neutral director appointed. We didn't create another class of equity. It was a closely held small business. And wife continued to get distributions. Husband got his compensation. And but there was a neutral director appointed to break ties who was a professional director appointed. So it was a variation on this approach, and it seemed to work for the most part with a lot of problems, yes.
And this cannot always be done because of the way the entity is structured with its corporate documentation, formation documents. And if there are other third-party owners or shareholders of the business, they may not consent to this kind of a structure. So you got to look at the corporate documents to see if this is even allowed. So alternatively, the next approach would be the holding company approach. And this means basically we would form a new entity, and the spouses would have ownership interests in that new entity, holding company, and that entity would in turn be the member, shareholder, partner of record for the underlying company. And this structure probably still needs the consent of the third-party owners, but it has benefits because with this new holding company, each ex-spouse has a direct interest in the holding company in their own names, which provides, protection because the bankruptcy or the creditor collection of one spouse then won't affect the other's interest. And with each type of holding company chosen, there are rules about which types of entities can be a holding company, but either with a corporation or a partnership structure chosen, there can be a separation in the holding company between management and ownership rights. Lastly, you can use the nominee approach. And with this approach, the business interest remains titled in the name of the operator spouse until something happens. And otherwise, until there's a valuation or in a buyout or a sale, and the operator spouse has a duty to distribute income to the other spouse. As family law attorneys, this is the one that scares us the most because we prefer a clean break. We want to have everything titled in our own clients' names and not held by one party on behalf of the other. That can result in, like I've said earlier, there are trust issues. It's probably going to lead to litigation. The other spouse will be accused of manipulating things, not turning over the income, et cetera. But sometimes it's simply not possible to use one of these other approaches. And so this may be the approach we're stuck with. But, as I mentioned, it's a sort of a creative approach of dealing with things, any of these. And but it is sort of fraught with danger and there are a lot of factors to consider. So make sure you engage a corporate attorney very early on in the process. So I'll turn it back to Alex to talk about, shift the focus to real estate.
Yes, thank you, Chrissy. So we have talked a lot about business valuations and how the value of a business could be impacted during COVID. We lost our slide here. I don't know what happened, Peter. But we have not talked about other assets that might be impacted that the parties also have to look at when they're doing asset division on the balance sheet. Real estate being one of them. So I will wait until we pull these slides back up just so everybody can follow along.
I'm working on it. We had a little glitch here.
I have it on mine too, Peter, if you want me to just pull it up.
Yeah, if you could, that would be great.
Okay. And then let me just go all the way down to the end. Sorry, everybody. Okay, so in addition to business valuations, other assets that affect the balance sheet that might be affected by COVID include real estate. And as Chrissy kind of touched upon earlier, it depends on what type of real estate you're talking about. Residential real estate has a lot of different implications of COVID than commercial buildings. So commercial buildings might be a lot harder hit, hotels, retail space. I have a case right now where husband wants to buy wife out of their hotel at a $90 million discount, which is kind of scary because you don't know, how long COVID will last and whether or not it will rebound quickly afterwards. So trying to advise your client on whether or not getting bought out at a $90 million discount is very challenging for family law professionals. So how can you mitigate one spouse buying the other spouse out at a severely discounted value? Co-ownership, like Chrissy was discussing earlier as it relates to a business, can be one way. And with real estate, I think that is a little bit easier than with, a closely held corporation with other partners. Also, you could sell the asset and split the proceeds. However, obviously, if the asset is valued a lot lower right now, on a temporary basis, it might not be the best time to sell. Another creative solution I've seen in cases is you can include in the marital settlement agreement. I don't think a judge could order this in a trial setting, but if you are settling the case with a marital settlement agreement or stipulated judgment, you could include a provision for a partial recoupment. An example of that would be just basically an additional equalizer if the asset is sold at a later date at a much higher value than the spouse got bought out of, a couple years before. So you can include that kind of provision in a marital settlement agreement to kind of try to protect your client from one spouse gaining an advantage due to the potentially temporary impact of COVID. Also, Chrissy also discussed earlier, securities also are obviously impacted and fluctuate in value a lot right now, as well as retirement assets. So for these types of assets, an in-kind division is really always preferred, but especially in the current economic climate, because there can be a lot of volatility. Stock options, for example, might be underwater. What does that mean? It means that the actual fair market value of the stock is less than what you would have to pay the strike price for the stock. But there could be a lot of upside in the future. There might have been a lot of upside a couple of months from now. So you don't want to assign those stock options at a low or zero value to one spouse. It's probably better to just have those divided in kind. Quick caveat, stock options generally can't be divided in kind. They have to stay with the employee spouse. So you would have to either exercise the options and receive the shares before you could actually divide them between the spouses, or one spouse would have to hold them in constructive trust for the other spouse.
A couple of things on this slide. Definitely you want to look at the tax impact of one spouse holding the stock options and paying the other spouse. You want to make sure they both take into account the tax in the transaction. Also, on retirement assets, often we try to save money on quadros, so we don't do 10 quadros if there are a lot of retirement assets. But if you're going to equalize the division of the retirement assets, you got to make sure that each party's getting the retirement assets that are similar to each other, so one doesn't take the hit on different kinds of, like travel industry, hotel. You don't want somebody to get those and the other person to get the stocks that are going to rebound. So definitely take into account tax consequences and a fair division of these assets.
Yes, and kind of touching on what Peter said, a lot of times if there are 10 IRAs, you don't necessarily need a quadro for an IRA, but if there are 10 IRAs that one spouse has 5, the other spouse has 5, and there's a differential in value, sometimes in order to make it administratively easier for the spouses, family law practitioners might just take a shortcut approach and just say, you keep yours, I keep mine, and I'll roll over an amount equal to half the differential of the total value of our assets that we're keeping. But like Peter said, different financial institutions, if I had all my retirement assets at Schwab and my husband had all of his retirement assets at Merrill Lynch, then there might be underlying assets within the retirement account that are, that could fluctuate differently. So if you roll over an amount today, tomorrow we could be in totally different positions. So during an the current economic climate, and probably in general, but it might be worthwhile to go through the extra administration of dividing every one in kind, just to make sure that both spouses will get 50% of the community assets.
So we don't know how long this will last. It may be for a couple of years. I mean, what goes down must go up. At least that's what we're all hopeful, that we'll get out of this and we'll be fine. And there will not be another like disaster, but these things happen. If you look at history, this has gone up and down, and we will get out of this. But take this into account by using some of the methods that we suggested, reserving jurisdiction to divide an asset, perhaps giving consideration for reserving jurisdiction to divide an asset, especially a business or a retirement plan. We also, we get a sense that we've borrowed a lot of money to make things sort of work during this period. Well, that's going to have to be paid back. Taxes are going to have to go up and up and up to pay for this. It's going to hit businesses. It's going to hit real estate. We've seen it here already. So take that into account. Things are going to be change in the future. A long-term recession, possible. Worse than that, possible. Start thinking about how to handle asset valuations based on current economic climate. Also, you have homework to do. Learn about the build-up rate. Learn about discount rate. Learn about the build-up method and the discount rate. Look at how people are treating this in the current economic climate. Thank you very much for attending our seminar. Good luck.
Thank you, Peter, Christina, and Alex. That was very informative, and now I have homework. So thanks for that. That concludes our first two panels. Our next portion is going to be our chat session, where we're going to split up into breakout rooms. We're going to do 3 20-minute sessions, and then a short break, and then the mock trial. The mock trial will be interactive. It's not just watching someone asked in the chat whether the mock trial will be interactive. So the mock trial was pre-recorded. You'll see Carrie and I playing bit roles as husband and wife. That portion is pre-recorded. However, Carrie and I and Alex Grager and I think Chelsea Stevens is going to be with us as well, who are both actors in the mock trial as counsel. The 4 of us will be speaking like a director's commentary over the pre-recorded session with our experience. And we actually used LACourtConnect. The LACourtConnect vendors were gracious enough to create an after-hours session just for us to record a mock trial so that we can present it to you. So if there are people here that haven't seen it before, they'll be able to see it for the first time. And we used it and interacted with it in real life. So we'll be able to share some of those experiences. All right, everyone, we're going to be muting everyone because we're staying in this forum. And we have 4 presenters, me, Carrie, Alex, and Chelsea, Alex Grager and Chelsea Stevens. And we're going to be playing a mock trial that we pre-recorded. And in addition to the 4 of us, Jennifer Magnes from White, Zuckerman, Warsavsky, Luna, and Hunt. And it's in the memory. And also Judge Marion. We're part of it. The 2 of them are not going to be commenting with us today, but we do have some comments from Judge Marion at the end of the clip. So we're going to be playing it in just a second, and we'll be interrupting the feed as we go to make comments and give our experience, share our experience. And then we'll also have time at the end for questions. So for those of you that don't know, if you haven't seen me already too much today, my name is Ron Reichstein. I'm from Youngman Reichstein. Carrie Holmes from the Harriet Buhai Center for Family Law, and Alex Grager and Chelsea Stevens, who are from FMBK. And we really appreciate their contribution to this. It took surprisingly a lot of effort to put all this together ahead of time, so that we had it for you guys to present today. For those of you that haven't done any virtual hearings yet, in LA, we're using LACourtConnect, which is very similar to Zoom. It's not Zoom. It is its own thing. So we were really lucky that Judge Marion put us in touch with LACourtConnect staff, and someone from LACourtConnect created an after-hours court session for us. So Judge Marion was actually in his courtroom, masked per usual, on LACourtConnect, and then the other participants were each at home or at their offices participating in LACourtConnect like a usual case. And you'll see that actual technical difficulties came up. We had real life situations, we had scripted situations come up, and we tried to deal with them the best we could. And also we built in failures so that we would have things to show you guys.
Yeah, we built in failures, and then there were also unexpected failures. So you get both.
Exactly.
I'm really glad to see a number of judicial officers here because, yes, we're going to run through the recorded presentation. We're going to interrupt it several times, but I really would love to leave some time on the back end to open up to the discussion about people's real world experiences, because my understanding is not only that the experiences vary greatly among the different courtrooms, but also I understand that a lot of people have not yet had the chance to actually put on a virtual trial as opposed to a virtual hearing where they actually have to present exhibits, deal with credibility issues, deal with impeachment exhibits and things of that nature.
Yeah, and we tried to touch on many of those things, but we also do want to give a little bit of a disclaimer. This is a short clip. This is not a full trial. We basically had direct examination and cross-examination of one expert witness. It's very limited in its substantive content because that really wasn't the purpose of what we were trying to present. We wanted to touch more on the technology aspect and the difficulties surrounding presentation of evidence remotely. Keep that in mind that, if you would have objected to something that Alex maybe wasn't objecting to, it's okay. It's going to be fine. And that's not really the point of the exercise. But you can let Alex know anyway.
Right, we can stipulate that everyone participating knows the rules of evidence.
Especially Judge Amarian.
Sure.
The other thing to note is LACourtConnect was not set up in the same way that Zoom is to record sessions. So this was a special dispensation that LACourtConnect provided that allowed us to record our session. As a result, the quality is relatively low. So some of the elements on the screen are illegible in terms of buttons that you would normally see, like in Zoom. You have the share screen option, the chat function. You can clearly see those markings on your screen even now. LACourtConnect, when it's native on your screen, like if you're appearing day of, you'll be able to see those things, but in this recording, the quality is lower. So you won't be able to see them. Also, a portion of the right side of the screen is cut off as a result of the recording. But I will go through all of the functions that exist on the screen, even if you can't see them at a point in time. So don't try and get too close to the screen to try and read something that you're not going to be able to read. So you're just going to end up seeing me too close, and that's not good for anyone. So this is the LACourtConnect interface. You get a link. If anyone's done it by audio, it's basically the same procedure. You go online, you set up your account, you set up the appearance, and instead of choosing audio, you choose video. It sends you a confirmation email. And in that confirmation email, instead of just a phone number, there's also a direct link from that email to a browser that will launch this LACourtConnect interface. And I believe you can use any computer system. I believe it works with Mac, though I've heard it's buggy. And I believe it works on mobile, though I believe it's buggy. So this was on a PC. Obviously, this was the LACourtConnect people's PC, and I was using a PC. I don't know. Did you guys use something else?
I was using a Mac, and I had to log in through Chrome. The other browsers were just kind of slow and a little glitchy and kind of not keeping up with the system. So I would recommend Chrome for sure if you're using it on a Mac laptop.
Yeah, so right ahead up front, they recommend using Chrome as opposed to other browsers, but I think it bears emphasizing. So Zoom is an actual app, right? We log into it through a web link, but you need to have a Zoom application. installed on your computer, or at least it's advantageous to have installed. From my understanding, LACourtConnect does not have a native app. Maybe it will in the future, but for now, you're basically just dealing with a separate open browser window.
Yes, and it you know, you can kind of see it's still in the browser window. You know, as it's displayed on your screen, it's still in the browser window. Right now, you're seeing the 6 of us that participated in the mock trial. If you were in court on a regular day, if there were other people attending, they could be attending your actual hearing. So you could see, I think it's 9 per page, and then there's multiple pages as well. Although it's up to the judge or the JA whether they're going to have people participate in all of the sessions. So you could potentially be listening to other people or watching other people's hearings, but you may not be. You may be in essentially a waiting room that would be able to, where you'd be waiting for your hearing to take place. And I think it varies, you know, because it's up to the judge and the judicial, the JA, the judicial assistant. It varies from judge to judge whether you're going to be in the waiting room or not. Okay, so anything else before I hit play on this?
Item number 3 on calendar. This is a matter of John versus Luetto, case number 20-BEFL 99999. Counsel on LACourtConnect, please state your appearances, beginning with counsel for the petitioner.
Good morning, Your Honor. Alex Grager for the petitioner, John, who is also present on CourtConnect. He's not in the room with me. He's on his own connection.
So that distinction that Alex made, does anyone want to touch on that? Alex, maybe since you brought it up.
Since I made it, I'm going to touch on it. One of the conversations that we've had prior to recording and people have been encountering and doing these types of hearings is, on the one hand, how do you ensure everyone's equal participation? But on the other hand, how do you avoid the situation where the lawyer and the client are in the same room, the client is off screen, they're talking to each other, they're texting, they're passing notes to each other. One of the things we talked about going on tape, and I think Judge Marion is going to say this a little later, is just making sure he will ask people if they are by themselves, if they're in a room alone, if there is someone communicating with them, just to ensure the integrity of the courtroom. We are trying to do this in a similar manner that we would in a real courtroom, where everyone would be able to see everyone.
And there's also one additional kind of procedural element to it, or practical, I guess, for the courtroom. The court reporter has LACourtConnect in front of them as well. And when the court reporter is taking down testimony, when they see the green box surrounding, so now you can see it's around Alex, they know who is speaking. And it's challenging if there's multiple people on the same call, if it's a telephonic CourtConnect, or if there's multiple people on a video, to decipher for the court reporter who is talking. And then you add to it interpreters, and it just can make it very messy. So that practical reason as well.
All right, and John just raised your hand via video.
Sorry, I see a message from Judge Puente-Porras that not all court reporters have the screen in front of them. So, you know, there is variance from courtroom to courtroom, but that was just a point that Judge Marion made, that it can impact the court reporter's ability to take down testimony.
All right, good morning, sir. I'll just tell the parties, we're not going to be taking testimony from you. Just, we'll have our judicial assistant swear you when it's time to do that. Now, counsel for the respondent, can you please state your appearance for the record?
Good morning, Your Honor. Chelsea Stevens, counsel for Respondent Lisa, who is also present via court call on her own line.
All right. I appreciate the parties having set up their own separate connections, it does create a challenge when counsel and the parties try to share a connection, because you may not realize it, but the court reporters use the visual cue that comes with every speaker. The speaker's box lights up. And so visually it's much easier for the court reporter to be able to keep track of who's speaking when you have separate connections. So I appreciate that. And if you're thinking about doing sharing a connection, or I think we've had some cases where counsel has had their clients on speakerphone and basically daisy chained them into the proceedings, that's not, we can't do that. So I do appreciate everybody having separate connections. Next, just to make sure everything goes orderly, I know in court we have the benefit of being able to see video and visual cues when it's time to stop talking. Luckily you're all on video, but in case the video goes out, or even if it doesn't, frankly, one practice I've learned is to prompt parties to talk. So please wait for me to give you a signal to speak. Lastly, I know that the way the system works, in my experience, it really only allows for one participant to be speaking at a time. It will broadcast one participant at the expense and exclusion of everybody else. If I need to interrupt you, that means that I need to speak louder than you, so the system recognizes me over you. So if I do interrupt you, be prepared for it to be very loud, and I mean no disrespect by it, no discourtesy by it, but it's just a function of the system. All right, and then one other thing, just make sure you have you're quiet as much as possible. We've noticed that the system is extremely sensitive when it comes to background noise, rustling of papers, clicking of things. We hear just about everything that goes on in the background, so just be conscious of that. All right, Mr. Grager, we're here on your client's RFO regarding reimbursement for expenditure of funds towards the acquisition of the community home. Are you ready to proceed?
Yes, Your Honor. I have an expert witness testifying in court today also.
So,
I just want to take a second and acknowledge Judge Amarian's introductory comments, which may have been a little long, and he probably wouldn't do this if this was not a virtual setting. But I think that's exactly what we're trying to show, which is everyone needs to be familiar with the rules of engagement. And I think it's helpful for a judge in the beginning of the hearing, both for the lawyers and for the litigants, to say, this is what I'm seeing, this is what I'm hearing, this is how I am viewing the process. And since I am, the most important person in the room, please follow my lead on this. And I think it's also reassuring to the lawyers, because one thing that I've struggled with, and you will see this in a few minutes, where on the one hand, when we are in the physical courtroom, making an objection is easy. You raise your hand or you stand up and you just say objection. Here, we were essentially told not to interrupt, which is always a good idea. But then how do you get the judge's attention quickly enough?
One other thing that Judge Amarian mentioned is that in order to be heard over someone who's already speaking, you have to get extremely loud. So I think he mentioned after we were finished that he feels like, he was shouting if he needs to get someone to be quiet, or he needs to give an instruction. So that's another kind of challenge in making objections, I think.
and this is a very dynamic situation. It's changing constantly. Even from one of our prep sessions to the day we shot the mock trial, Judge Amarian had additional notes of things that have come up, and that was about a week or so of time that had gone by. So, the judges are learning and dealing with these things on the fly, just like us as practitioners. I know in some of the breakout sessions earlier, I was asking people about whether they've been doing telephonic or video or in-person sessions, and it sounds like there's still a lot of people, at least in this group, that are going in person, but certainly the the judges, while it's easier logistically for everyone to be in the courthouse, they do want to keep attendance low. So they are working to try and make this work. But it's a process.
Via LACourtConnect, and I would like to call that witness at this time.
All right, call your witness.
Okay, calling Jennifer Magnes. Ms. Magnes, can you hear us?
I can hear you.
Okay, great.
Ms. Magnes, I'll administer the oath. Can you please raise your right hand? Do you swear and solemnly promise to tell the truth, so help you God?
I do.
All right, thank you. Now, Mr. Grager, before we proceed with Ms. Magnes, let's make sure we're all on the same page with exhibits. Can you walk us through that? I see I received an exhibit binder from you, which I greatly appreciate. So how do you plan on dealing with exhibits?
So this segment about exhibits is really kind of crucial to the whole remote appearance thing. And actually, in a breakout session with Judge Puente-Porras, she mentioned preparation is everything. And as you'll see in the clip, that's the truth. So Chelsea or Alex, why don't you walk us through what we're about to see?
Okay, Chelsea, you want to take this one?
Yeah, sure. I can take this one. Hopefully my internet connection has sorted itself out and everyone can hear me clearly.
You sound fine on this end, although we're in
Great, good,
oh.
good. So what we're sort of about to address is the idea that when you're in a courtroom, you usually bring your exhibit binders. You bring one for the witness, you bring one for the judge, you bring one, for the clerk, that kind of situation. And when you're appearing remotely, most people assume, oh, great, I'll just throw my exhibits up on the screen. But you're going to encounter all sorts of issues of pre-exchanging and whether those exhibits can be read clearly on the screen when you put them up, and whether your opposing counsel can verify that those exhibits are the same ones that you hopefully pre-exchanged before your hearing or your trial. So the practice that we sort of discussed with Judge Amarian and was his recommendation as potentially one of the practices that he thought was best was to circulate exhibit binders in advance, maybe FedEx them to your opposing counsel, FedEx them to whatever witness you're going to have looking at them, and make sure you supply a copy to the court so that everyone has a physical copy that they can be looking at while also looking at the exhibit that you're going to share on the screen.
Yeah, so that's where the prep comes in, having all those things together and having them sent out both to the parties or opposing counsel, witnesses, and the courtroom is key. One of the other elements we talked about that's a little more tricky than throwing into a binder is presenting video evidence. We didn't do it for this session, although after the session, while we were playing around with the features of LACourtConnect, we did try sharing a screen of a video, and it didn't go very well. It probably went about as well as this is going. So it was choppy. The sound wasn't great. So some solutions that we came up with that you guys could try, because again, everything's changing all the time. One is you can get a cheap tablet on Amazon. I think for $50 you can get an Amazon Fire tablet. You can throw your content on there and have that delivered with your exhibit binder and a charging cable. You could probably even put your digital PDFs of your exhibits on there as well. But if you send that down to the courtroom, you can actually have the videos for the judge to see almost in native form. The other maybe less appealing because it doesn't come out as well is if you've got the video on another device, you put the device up to the camera and you would show the video and play the audio through the camera. as opposed to the share screen. So those are just a couple of things that we tried out and ran through, and they seem to work. But videos especially, they come up a lot in the DV context. You may want to think about how to get them to the judge. You definitely don't send a thumb drive. That's one thing that's for sure. And
yeah, I want to get through the video presentation because there's so much to talk about. But obviously, talk to your judge and talk to your clerk because, as much as we're learning this stuff, I understand that different judges may have different sort of receptiveness levels of how they receive this stuff. And I don't know if every judge will be comfortable receiving an iPad and, going through the documents and opening the various apps to do that. And so I almost feel like all of that needs to be prearranged at hopefully some sort of a final status conference, because when you just show up to an evidentiary hearing and you know what evidence you want to present, unless you have prearranged all of this in some great level of detail, this is not really going to work. I know I'm sort of skeptical about this a little bit, so that's just maybe my view, but I think this requires a lot more planning than just showing up in court and, well, bringing your evidence with you in whatever form you're going to present it.
As someone, everyone in our firm has avoided court since March. So, coming from our camp, this has to work. This is what we're doing. So to the extent that it's difficult, it just takes some more planning, and that's really why we thought this would be useful. So hopefully so far it is, even though I'm sure we're going too slow for you. So let's keep going.
So, what I plan to do, yes, we sent an exhibit binder to the court. There are 4 exhibits, and when it comes time for me to question Ms. Magnes about each of those, I am just going to share my screen, which I think I can do here, and she'll just answer my questions.
Okay. Ms. Stevens,
Your Honor, if I could be heard for just a moment on this point, I did not receive an exhibit binder. I'm not sure what Mr. Grager is referencing.
Everything is showing on my screen.
Hold on. So again, I can't have you both talking at the same time. What you just said is probably very important to you and your client, but we got none of it because you're both talking at the same time and talking over each other. So, like I said at the beginning, let me guide the discussion and prompt it. Mr. Grager, I promise you I will give you a chance to respond. Okay? So, Ms. Stevens, back to you. Go ahead.
Thank you, Your Honor. I apologize. I was saying I did not receive an exhibit binder. I haven't had an opportunity to see what these exhibits are that he's referring to. I did receive an exhibit list, but I have no way of verifying whether the exhibits he intends to produce today are those same exhibits that were exchanged prior, according to the court's order.
All right, Mr. Grager, any ideas on how to allay Ms. Stevens' concerns?
So I have a solution. All of the exhibits except for one have been exchanged but not pre-bait stamped. The others are bait stamped, and I can go through the bait stamp numbers real quick for Ms. Stevens to confirm that she has that which I will be sharing on my screen. Exhibit 1, does not have a bait number. Oh, sorry. Hi.
Okay. So, Ms. Stevens, does that approach work for you?
It does, Your Honor. Thank you.
Okay. Mr. Grager, go ahead.
Okay, so the exhibits are going to be a bank statement, which is bait stamped 022, a bank statement that is bait stamped FMBK 027, and an escrow statement that is bait stamped 003. With respect to my one exhibit that is not bait stamped, I suggest that since the court has a hard copy, and I will put it up on the screen, if there is a concern about that exhibit, we can take it up during that time. Does that work for everybody?
Stevens?
That works for me, Your Honor. The exhibits that were pre-produced do have the same Bates numbers, but I would like an opportunity to review them as they're shared on the screen.
Okay. All right. Mr. Grager, you may proceed.
Okay, thank you, Your Honor. Ms. Magnes, what is your occupation?
Forensic accountant.
And Ms. Magnes, how long have you been a forensic accountant?
For a little over 16 years.
And where do you work?
White, Zuckerman, Warsavsky, Luna, and Hunt.
And what is your title, if any?
I'm senior partner.
Okay. And what are your duties as a forensic accountant at White Zuckerman?
Well, I mainly work on family law matters, so income available for support, community property balance sheets, tracings, reimbursements, marital standard of living, things of that nature.
Have you ever testified in court?
Yes.
And approximately on how many occasions have you testified in court?
Between 35 and 40 different cases.
Okay, thank you, Your Honor. At this time, I would like to tender Ms. Magnes as an expert witness in family law forensic accounting.
Any objection, Ms. Stevens?
No objection, Your Honor.
Okay.
Thank you. Oh, sorry for interrupting. Ms. Magnes, what were you asked to do in this case?
I was asked to inspect certain documents to determine if the petitioner's inheritance remained on hand within a bank account and then was subsequently used for the down payment on the party's real property.
Okay, and did you reach any conclusions in this regard?
Yes, I had noted and identified that the petitioner's inheritance was deposited to a Bank of America account, remained on hand until the funds went out to the escrow in the amount of $47,111.
Okay, and which documents did you examine to arrive at your conclusions?
I examined there's a text message between the parties. There is a bank statement covering the period January 25, 2019 through February 21, 2019, and the escrow closing document.
Okay, so let's take those one at a time and talk about those. And Your Honor, at this point, I would like to introduce my Exhibit 1 that has been pre-marked in your binder. So with the court permission, I would like to share my screen and show Exhibit 1 and talk about it.
All right, any objection, Ms. Stevens?
No objection, Your Honor.
Okay, so this is a better shot of what is actually seen on the screen. As you may notice, this right side, I don't know if you can see my mouse move, but this right side is cut off in the video. I'm going to walk you through what these icons are that you can't read and what you don't see. So this is a leave option to leave the chat. Not the chat, but the LACourtConnect. This is the share screen button. And the next part of the video will walk you through that part. This hand, it's a hand raised, is alert operator. And what we learned is that when someone clicks alert operator, it sends like some kind of message to the JA, letting them know that the individual is trying to get the attention of whomever, the judge or the JA. So they can respond to it or not. They may not see it because it would just show up on their screen. The next option is audio on. This is the equivalent of the mute button on Zoom. Next one is video on. Then there's settings. I don't recall, did you guys play around with the settings at all?
Don't recall playing around with the settings. There are a couple of things to say about the speaker screen, which is right below your mouse right now, and the share screen when we get to that. But we'll do that in due time. Yeah,
and this last one is full screen. I think with regard to the settings, it was very limited adjustments. So you pretty much won't need to go there. So let me, Alex, why don't you go ahead and talk about the share option?
Right. So I think maybe we should play it a little more, and because I think we've built in a fail in. Yeah. So why don't you play the video a little bit, and then we'll pause it again.
So I actually spliced this into the video so people
this
can
was
see.
not in the this was not in the brochure. Okay. So what we did, all right. So by trial and error, an important thing that we learned as far as the screen share is the following. When you are, and this is to me a significant difference between Zoom and LACourtConnect that you need to know. So before the trial, what we did is we prepared our exhibits in PDF files and we placed them in a separate folder to have them readily accessible. When it came time for me to share my screen and to introduce my exhibit, I shared my screen with the intention of then quickly going to my folder and opening up the relevant document. Turns out that unlike on Zoom, you cannot actually do that. So when you share your screen on Zoom, your viewer basically sees you in action. You can change things on your screen and the screen will follow whoever is watching. Not so on LACourtConnect. The screen is sort of frozen in the mode that you're in at the time you share. So what that means is that you have to open up your document first, have it positioned on the screen where you want it, then share your screen, because your screen will then share that which is actually directly on your screen. And if you want to move between the documents or between pages of the documents, I think what you have to do is keep clicking share again, because the screen share will not track what you're doing in your own computer.
So yes, and up here at the top, if you can see the image, this says your entire screen. So I think this is similar to Zoom. You can share your entire screen, or if you have multiple windows, they'll show up here. And then this is application windows. So this is any application that you have open, it should recognize and let you share. So in this instance, there's a PDF. So you could click on the PDF and share it, and then it would pop up on the screen. But you have to make sure you move from the first tab of your entire screen to the second tab of application windows in order to get that option. And since we have it up on the screen now, can you see the, Alex, you were going to mention the presenter mode or the viewer mode.
Yeah, and I don't think it's actually as relevant to this particular screen. The only thing I wanted to say is the speaker window is usually bigger than the others. You can't really see it on this particular screen, but what is possible to do is separate the speaker window out and just have it not covering part of your main screen so that it doesn't cover whatever else you're trying to present or the rest of the document.
Okay, so I'm going to go ahead and share my screen, and I am going to open up my case file here, and I'm going to open up the exhibit. Ms. Magnes, do you see the exhibit on my screen?
No.
You don't?
No, I see
You're
a
on?
folder that says John case, and there's exhibit 1, exhibit 2, exhibit 3, maybe a PDF file, that's exhibit 4.
Does the court see the same thing, Your Honor?
I do, Mr. Grager.
Okay,
I think you need to,
hold on.
I think you need to do it a different way.
So let me try this a different way. Let me unshare my screen. Let me open up the exhibit first, have that on my screen, and then share my screen again. 1 second. Let's see. Okay, I think now it's going to work. I apologize for the delay because Ms. Magnus, can you see the exhibit now?
Yeah.
It's so tiny.
Lisa,
Okay.
was that you?
Yes.
Okay. I'm
It's
gonna,
so small. No one can see it.
Lisa, I'm going to have to ask you, we'll deal with the size of the font in a minute, but I cannot have any interruptions. So please let Mr. Grager finish his presentation. Again, like I told Mr. Grager earlier, both sides will have a chance to present their case, but I cannot have any interruptions from you in order to make sure this goes smoothly, okay?
She knows the text message anyway. She sent this text message.
John, just like I told her, I can't have any interjections. I've got a courtroom filled with people here. I've got a whole waiting room filled with people in LACourtConnect. They would be just as happy to have you wait until the end of my day to call the case. I don't want to do that. So if I have to warn the two of you again, I'm going to put this on second call and take somebody else who's waiting patiently for their turn. Do you understand?
Yes, Your Honor. So this was a fun vignette. Carrie, do you want to talk about it?
Sure. So Ron and I played the parties, and poor Chelsea had me going rogue. I think, one issue that we're going to come up against in these kinds of remote appearances is the issue of client management and client control, because you're not physically next to your client. So I think the key takeaway of everything we've talked about today is preparation, and that includes client preparation, because obviously that outburst is incredibly frustrating for the court, and is not helping anybody. So I think that preparation really extends as well to preparing the client.
If I could just follow up on Carrie's point for a second. Thank you. Something that I think is important that I'm learning just from seeing this view, because it doesn't quite look the same on the other side, which is I can't actually see who's speaking, right? You can't see anybody in this view. And that makes it a little bit harder to tell, like, is it a lawyer speaking? Is it a client speaking? What's sort of happening in that sector? And it probably makes it a lot more difficult for the court and for the court reporter to kind of figure out, who's talking at that time. And something else I sort of wanted to follow up that Carrie said was in terms of client preparation and expectation for the hearing, it's probably pretty important to figure out how you might want to communicate with your client during the hearing, especially if they're appearing from a separate location, which is probably better than being in your same office space with you just for feedback purposes. If people have their microphones on or their volume on at the same time, it kind of creates this weird feedback loop. So probably a better approach to have someone in the separate space, but then figuring out, if your client wants to tell you something, they're not next to you and can't poke you or pass you notes or whisper to you or things like that. So you probably want to develop a way that is comfortable for you as you're doing the appearance on the screen and looking at what you have up on your screen, and something that's comfortable for your client to be able to send sort of quick communications or notes or things like that to you during the hearing.
Yeah, one comment from Judge Puente Porras that I think is really good, especially in this kind of context and also for the just straight phone appearances, is all the bench officers that I think we've heard from have wanted a counsel to state their name before they start speaking. And so especially on this kind of view where you can't see who's talking, you heard Judge Marion ask, was that Lisa, which was the wife in the case. So I think it's a great note for counsel to say, this is Chelsea Stevens representing respondent, whatever, before you start talking. And then the other comment that Judge Puente Porras had that I think is great is speaking slowly and pausing between your sentences, because the acoustics in the courtroom are not great and the kind of audio system is a little challenging as well. So that kind of slow speaking, identifying who you are, pausing between sentences are all really good notes, I think.
I think these are really helpful pointers. I think I would like with Ron and if Ron and Carrie are okay with, they kind of want to run through the next maybe 5 minutes of this without interruptions because they really want to get through the exhibits and get to the cross-examination. We were worried that we will not have enough to talk about, but I'm looking at the clock and I'm realizing that's definitely not the case. But this may also be a good time to give a shout out to all of our judicial officers and just a plea for patience and sort of all around kindness. We are not trying to annoy you. We are figuring this out as well. And so thanks to all of the judicial officers who recognize this and who help us get through this and do this efficiently on behalf of our clients.
All right, thank you very much. Lisa, do you understand too?
Yes, Your Honor.
Thank you very much. Mr. Grager?
Your Honor, if I could, I apologize for interrupting. If I could be heard for a moment on this.
Yeah, go ahead.
Thank you. It sounds like everyone's experiencing the same thing that I might be experiencing, which is this text message is very small on the screen share, and I'm unable to read what the text says. And this sort of harkens back to the issue I raised earlier about not exchanging exhibit binders in advance. I can't verify that this document is what was previously exchanged. I can't read it. I don't know if it's the same text message that I received before this hearing.
Okay, so what I'll do is I'll tell you what I see, and for the record, and then you can tell me whether that is what you have in front of you as Exhibit 1. What I see is a screenshot. Looks like it has a time of 4:07. The profile indicates that it's sent, or it's a conversation involving a contact named Lisa. The first statement is from the is with a blue background, and it says, quote, "We are good to go. Dad agreed to give us the $50,000 for the down payment. He says I'll get $50,000 less when he," and I believe these are probably typos, but it says, "when he does though," DOESTHO. And then there are 3 emojis. One is a yellow face. I believe it's crying, but it's hard to tell. The next is a skull, and the third emoji I can't make out. The next conversation box, text box, is with a gray background, and it says, quote, LOL, in all caps, hyphen, so nice of him to help us buy a house together. 123 Maple Lane is ours, exclamation point, unquote. Is that the Exhibit 1 that you have in front of you?
It is, Your Honor. Thank you for reading that. I appreciate it.
All right, you're welcome. Mr. Grager, go ahead.
Okay, Ms. Magnes, can you tell us what is the significance of this text message?
Yes, so this text message exchange lends me to understand the intent of the parties in as much as it appears that $50,000 was received. It was earmarked specifically for the down payment of the property, and there was an understanding that this was coming in from the inheritance, as there is an acknowledgement of there will be less. I believe it was probably supposed to say I'll get $50,000 less when he dies, though.
Thank you. Your Honor, I'm going to unshare my screen because I'm done with this exhibit. And with the court's permission, I would like to introduce my Exhibit 2 in the same manner.
Any objection, Ms. Stevens?
No, Your Honor.
All right, Mr. Grager, you may proceed.
I am going to go ahead and try to not make the same mistake, so I will open up my exhibit first, and then I am going to share my screen. And let's see here. Can everybody see that?
Yes.
This is what has been pre-marked as Exhibit 2, bait stamp number FMBK 022. Does everyone see that?
So it's small, but I have my hard copy, so I can look at it.
Okay.
I have a hard copy you provided the court as well, so I'll use that if necessary.
Okay. Ms. Magnes, have you seen this exhibit before?
Yes.
And what is this? And what does it signify?
This is a Bank of America account for the period January 25, 2019 through February 21, 2019. And this reflects the deposit of the $50,000 on January 28, 2019.
And is this the deposit? Can everybody see me pointing at the transaction? Is this the deposit that you're describing?
That is my understanding.
Okay,
All right, and
thank
just
you.
for the record, Mr. Grager, can you describe where on Exhibit 3 you're pointing with the pointer?
Yes, Your Honor. It is the last line of text, essentially. It is, oh, let me see. Wow, it is small. Wow, okay. It is January 28, 2019, deposit $50,000.
All right, and it's under the heading Deposits and Other Additions, is that correct?
Yes, Your Honor. Thank you.
All right, go ahead.
I'm going to close this exhibit. I'm going to unshare my screen. And I am going to ask the court if I can introduce in the same manner exhibit number 3.
Any objection received?
No objection, Your Honor.
Hello? I'm in court. I'm going to have to call you back later.
John, please.
I'm sorry. Right to me?
Oh, I'm sorry. I thought my mute was on.
Please, silence all cell phones. You got to treat this like you were sitting in my courtroom.
I apologize, Your Honor. Let me turn this off.
Thank you. And everybody else, please make sure all other cell phones are off. This is the last time I'm going to admonish you.
Okay.
Mr. Grager?
I would like to introduce exhibit 3, which has been pre-marked. I am going to share my screen. And this is exhibit 3, which is barcode. Oh, I know. I can make this bigger. And I think that's going to be helpful. Can everyone see this? This better? I can actually move this around.
Yes.
Okay, does this work for everyone? Good. Wow, okay.
Yes.
Ms. Magnes, directing your attention to what has been pre-marked as Exhibit 3 and specifically a transaction on February 14, 2019, towards the bottom of the page, a wire out of $47,111 and change. Do you see that transaction?
Yes.
And what is the significance of that transaction?
So this page of the statement is from the same account that we were just referring to with Exhibit 2. Based on my review of the transactions, the $50,000 was still on hand in the account at the time that this $47,111 was wired out. And it is my understanding that this wire out was used for the down payment on the party's real property.
Thank you. Let's confirm that understanding. With the court's permission, I would like to go on to my last exhibit, which is Exhibit 4. I'm going to go ahead and share my screen. Let's see here. Here is Exhibit 4. Magnus, can you see that?
Mr. Grager?
No.
Mr. Grager?
Yes.
All right, your video has cut out. So,
No, I can see everyone fine.
all right, well, we can no longer see you, and I have a feeling we're not going to be able to see your screen when you share it either.
You cannot see the shared screen?
No, we cannot.
Oh.
So you're going to have,
Oh.
I'm not going to wait for you to figure out how to fix the technical issue. But luckily, since you sent all of us your exhibit books beforehand, we'll just have to go off of the hard copies that we have in front of us individually, okay?
Okay. Ms. Magnus, can you hear me?
Yes.
Do you have Exhibit 4?
My Exhibit 4 is FMBK 03.
That's right, Your Honor. Is that what you have too?
Yes, it is.
I'm sorry, I don't know what happened with my video. Okay, Ms. Magnus, can you tell the court what is the significance of this exhibit?
Yes, this is a page from the closing escrow. It reflects for real property being purchased. It reflects that there is a sale price of $240,000. Closing costs paid at closing of $66.95. Some taxes of $400, 76 and 13 cents. There was an initial deposit of $7,000, a loan of $192,000, title insurance of $602. It shows that cash is required at close of $47,000, $569.70. Then there's a whole calculation at the top regarding cash to close, talking about the closing costs and some estimates for the deposits and the down payments.
Ms. Magnes, I think you've answered the question. It helps, especially when doing these remote hearings, it helps if everybody can keep their statements brief and concise, so that way if the court needs to interject and redirect the proceedings, we can. So, Mr. Grager, do you have another question?
So that was part of an exercise that Judge Amarian pointed out that is relatively common, which is runaway witnesses, where a question is asked and they just take off without really any way to stop them. So sometimes it comes down to prep and training. Sometimes the judge has to intervene.
Yeah, so this was, there was a series of things that happened here that sort of led to this runaway train where the video fail was an intentional built-in to emphasize essentially the need to pre-mark and pre-exchange exhibits because, as you will see in just a few minutes, when there is cross-examination, that will not be the case. Going back for and then of course, if my video is not working, the court can see me and I guess I said in there that I can still see everyone, but there's not much I can do about it because my video is not working, so I can shout at my witness. But to that point, I want to go back for a second to the place where Ron picked up the phone. Two things in there. Of course, in real life, that would never happen because I hope that all of my clients know not to pick up their cell phones in the middle of a live hearing. And the fact that he was muted, he believed he was muted, is probably irrelevant because he still shouldn't do it. But I wonder if anyone's paid attention to what was happening on the screen, because the screen just went crazy because, the light for the speakers kept changing because several people were speaking at the same time. And I can see how that would be really frustrating to the judge and to the court reporter because, as Ron mentioned earlier, the system can only pick up one speaker at a time. And this was a situation where multiple people were speaking at the same time, making it impossible for the record and for the judge.
I have nothing further, Your Honor.
All right, Ms. Stevens, cross.
Thank you, Your Honor. Good morning, Ms. Magnus. How are you?
Oh, I think my video is working again.
It looks like it is. All right, Ms. Stevens, go ahead. But now your client, I believe your client's video has gone out. Just give me one moment. John,
hold on. Let me call him. Can you hold on? I'm going to try to call him.
No, Mr. Grager, don't do that. Okay. John, can you hear me? John, can you hear me? All right. It appears we've lost John. Mr. Grager, what were you saying?
No. I'm sorry?
I just want to point out that I actually lost my internet connection, so all of this is totally improvised, And Judge Marion had no idea it was going to happen, obviously, but you should start seeing for your consideration banners around town, because you definitely, you just played it off perfectly.
John, are you there? All right, Mr. Grager, are you willing to proceed without your client? Well,
you're not solving the problem, so I guess I have no choice.
Well, if you want to, we'll make sure the issue is resolved before we proceed with his cross-examination or his testimony. Do you want a moment to try and contact him and see what's going on?
I think it's okay, Your Honor. I think we can just try to go ahead.
All right. The record will reflect that John is no longer present at the hearing. I'll interject Ms. Stevens when and if he rejoins us, but you may proceed.
Understood, Your Honor. Thank you. Ms. Magnes, you concluded that the petitioner has a separate property reimbursement in the amount of about $47,000. Is that correct?
That's correct.
And you referred to the $50,000 deposit as an inheritance, correct?
That is correct.
And what was that conclusion based on?
I had discussions with my client as well as counsel's representations that the petitioner would be testifying to that information, and also that text message, the Exhibit 1 that we looked at earlier.
Were you presented with a copy of the check for the $50,000 in your review?
No.
Your Honor, at this time, I would like to share my screen so that I can introduce a copy of the check that I just referenced.
Your Honor, I have an objection.
All right, one moment, Mr. Grager. Ms. Stevens, what's the purpose? Are you offering this for impeachment?
Yes, Your Honor, that's correct.
Well, I still have an objection.
I'm sorry, Mr. Grager?
I still have an objection.
Okay, I'll hear from you in a moment. Have you shared this document with Mr. Grager?
This document was not produced with our exhibit list as it's an impeachment exhibit, and there was no obligation for us to produce that exhibit at the time.
All right, Mr. Grager.
Well, that's what I'm trying to tell you. I've never seen it before.
All right. Ms. Stevens, can you please, what I would suggest is that you email it to Mr. Grager right now, and he can review the document before you share the screen. Can you do that?
I can certainly do that. Yes, Your Honor. I'll do that right now.
Mr. Grager, let us know when you receive the email.
I have received it. I am not going to text Ms. Magnes to ask her what she's going to do about this now. Go ahead.
All right.
Okay. Give me.
Hold on. One moment, Stevens. Now that you received it, Mr. Grager, do you have any objection?
I do not.
All right. Go ahead, Ms. Stevens.
Thank you. Give me one moment to share my screen, please. Here we go. Okay. Ms. Mannis, can you see this check that I'm showing you?
I see half of it.
Half of it. Is this better?
Yes.
Great. And do you see the payee line of this check?
Yes.
Oh, Your Honor, the client is back.
Yes. All right. Thank you, Mr. Grager. Yes, John has rejoined us.
Sorry, I lost my connection.
All right. Ms. Stevens, please resume.
Thank you. Thank you. And do you see here it says John and Lisa?
Yes.
And the memo line says down payment, correct?
Yes.
And the date of this check was January 25th, 2019, correct?
Yes.
Okay. I'm going to stop sharing the screen now. Okay. And was that check deposited into a joint bank account?
Yes.
Or were there funds in that joint bank account at the time the check was deposited?
Yes.
And were there funds in the account after the $47,000 came out?
Yes.
And was the amount of the down payment $47,000?
I believe the total down payment was approximately $54,000, but just that one transaction to close escrow was approximately $47,000.
So there's another transaction before that.
Yes.
Your Honor, if I could please have the court's permission to share my screen to show another exhibit.
All right, what exhibit is that? Can you describe it?
It is the prior month's bank statement for the joint account, the January 2019 bank statement.
All right, Mr. Grager?
Does it have a base stamp number in it? Because I cannot tell if I don't know, have it.
Yes, it does. It's base stamped FMBK 00014. It's your
Okay,
exhibit,
I have.
or your document. Yeah.
I have that.
Okay. Okay.
All right, Ms. Magnes, do you have that as well?
I can find it. Yes.
All right,
Yes.
Ms. Stevens, your screen too?
Yes. Give me one moment.
Go ahead.
Can you see the exhibit, Ms. Magnes?
Yes.
And do you see here this yellow highlighted transaction that I'm also sort of highlighting, not expertly?
Yes.
And was this the deposit that came before the $47,000 in February?
Yes.
This made up the remainder of the down payment?
That is my understanding.
And this deposit's from the joint account, correct?
Correct.
And there were community funds in this account at the time?
Yes.
Okay, I'm going to stop my screen share now. Okay. I have no further questions, Your Honor.
All right, thank you. Mr. Grager, anything else?
No, that's it.
Well, this concludes the testimony of this witness.
Testimony.
All right, thank you very much, Ms. Magnes. You're excused.
Thank you.
All right, next witness, Mr. Grager.
Okay. All right.
We can
So
stop for applause, maybe.
that's okay. Chelsea, how did it go with the impeachment exhibit? Because I am thinking emailing it to the other side as you go seems to be the only way to do it, but then you need the court's permission to do it, I guess. And then the court has to be okay with only seeing it on the screen and not actually having a hard copy anywhere in the courtroom, and the witness too.
I think that's right. As I was, kind of preparing how I was going to introduce that exhibit, I was sort of thinking about it, and that's really the only solution I could come up with. I'm sort of curious to hear from maybe other practitioners, other judicial officers that are here with us, if they've done it in a different way, if they have any suggestions of how they might want us to do that going forward. I'm sort of curious to hear from the audience if anyone has thoughts on that.
Right. The only other thing I wanted to point out is, of course, so for my part of the presentation, we had my exhibits pre-highlighted, and then we took that off to show, to build in the fail of how do you point out something specific on a page, especially on a bank statement that has 30 transactions on a page. And then, of course, in the cross-examination part, in Chelsea's part, she did it better because the exhibit was truly pre-marked and, of course, made it easier to see the relevant line. So that's a good tip to the extent that you need to highlight something on the page, whether it's a deposition transcript, a financial document or whatnot, just pre-highlight it, knowing that it's going to be easier for the judge and the witness to see it once you put it up on the screen.
Any other notes from this side of things?
Now, we have about 20 minutes left. So for those people who are still with us, I really would like to open it up to some questions and comments. Judge Amarian, who graciously donated his time to do this, was very interested in the exercise. We spent a lot of time talking about how this is done. And I understand that there is a lot of differences between the judicial officers and perhaps they don't speak to each other as much as they should about the best practices in their respective courtrooms. So I would really love to hear from people and talk about any questions, any way to do this better, any other experiences.
And while people are kind of formulating those ideas, I'm just going to play. Oh, Sharon, I think you're marking up the screen.
I did not know you could do that.
Me neither. But I'm going to play Judge Amarion's a little snippet about his post-mortem, essentially.
Perfect.
So, Your Honor, if you want to take off your mask and share some of your, I know we're not going to have you on November 7th when we're actually doing this presentation live, so maybe while we have you on tape, maybe you can share some of your impressions of what we just did.
All right, so I think what we just saw was a really good example of how to have to adjust on the fly to some of the technical issues that we've been confronting throughout ramping up. One thing that I think is important for everybody to keep in mind, whether you're in the courtroom or not, is that this is a system that wasn't even planned to be rolled out for another year at least. And then at that, it was going to be rolled out over the course of 18 months. So the pandemic led the court to issue it, roll it out this year and much more quickly than we had originally anticipated. So it's basically rolled out over the course of 90 days over the summer. But you know, most of the hearings right now, you can only appear by audio, and so you can see when you have the ability to have the visual cues of who wants to interject and who doesn't, it's a lot easier. But without that, it is very important for everybody to be very conscious of not speaking for too long, especially when you're using the services of an interpreter who's here in court, because they need to have things in sound bites so that they can interpret without forgetting what's being said. So that's also been a challenge when we've done things via LACourtConnect. And then the other thing is to just keep in mind that, like I told the participants, the only way for the court right now to interrupt is to have to speak louder than whoever's talking on the LACourtConnect. So it has led to instances where I am practically screaming at the top of my lungs because there's no other way for anybody to hear what I need to say to try and divert what's going on. So we're learning every day. We appreciate everybody's patience, starting from the bench officer as we all get used to a new way of doing these hearings.
Okay. Let me stop sharing.
Good.
Okay, so does anyone have any questions? Since there's nothing in the chat box, go ahead and click on the reaction in the bottom right of your screen next to the record feature and give us a hand up or a thumbs up if you want to be called on. So Steve Mindel. I think you can actually we'll call people out and then you can unmute yourself. So I saw.
So Ron, while you're looking at the screen, calling you out, someone just posted, and I'm sorry, you know, so Steve Mindel, if you worked for him, would kill you for not having your name on your, you know, on your identifier on Zoom. You know, so I can't see who the question is from because it just says iPad 9. But the question is a good one, and it's something that we tried to address earlier, which is since it is hard to hear more than one person speaking at a time, how can the court hear an objection being made over the ongoing question? So I think it's a real issue. And even though our judicial officers have told us don't interrupt and don't speak over each other, I don't know of an efficient way of just loudly, politely, but clearly saying, Your Honor, I have an objection, because my concern is by the time I raise my hand, depending on how many people are on the screen, and by the time the court recognizes me, the witness may start answering the question or answer the question. Just like it is difficult to get the evidence in this way, it seems it's equally hard to keep it out.
Yeah, exactly. And we didn't really have too many objections in the demo, but Judge Marion made it pretty clear that you kind of have to just go for it and be heard. So I think the first hand I saw up was Steve Mindel. If you want to unmute yourself.
Unless he was just giving us a thumbs up.
I was just giving you the thumbs up.
Oh.
Sorry about that, guys.
That's a good
Thanks,
finger.
Steve.
Thank you.
Thank you.
There is another question in the chat. Let's see. If only one party appears via LACourtConnect and the other party and their counsel appear in person, will there be sufficient screens in the courtroom for everyone to see everyone? Ron, you've said that you guys haven't been going physically into the court a lot, so I don't know, Chelsea, I don't think you've been going to court physically too much.
I've only been the one time we just went.
Okay, so I do about half and half. I still believe that for an important substantive hearing, I'd rather be there in person. So I've had a chance to see maybe 5 or 6 different courtrooms, and I can report that every courtroom is a little different. So every judge has a camera on their on the bench, and there is a camera pointing at the counsel table. As far as the screens, the courtrooms vary greatly. I've seen some courtrooms where there is a big screen TV on the wall, as if it's always been there. I've seen courtrooms where there is a screen and a projector, and it works pretty well. But then I was in downtown, and in one of the courtrooms, I didn't see anything, and so I asked the clerk, so how do you guys do the video thing? And they pointed me to this regular size desk monitor. It was kind of sitting in a well facing the court reporter. Said, well, when we do a video hearing, we just kind of turn that around so everybody can see it. And I can't, it's hard for me to imagine that would be very efficient to, again, it's not just so much for the purpose of seeing who is speaking, but certainly if you're trying to address a document or something particular on a screen, that would not be very efficient. And I think we all know the answer to the question of, oh, what happens if I just want to bring my own laptop and connect in? I don't think you can be on in person and on LACourtConnect at the same time. But it's an interesting thought about bringing your own device and what you can do with that.
So I've done 2 video and the rest were all audio. Audio works perfectly fine, just like, wow, now I forget what the old system was called. Court call.
Court call.
So just like court call used to be, it works just as well. In fact, I think even better. The video, both times I just had a screen facing the judge. I didn't have anything facing the audience or the well, and it could have been because the other sides were also remote, so they didn't turn it on. But I think it also just varies from courtroom to courtroom.
There's the new restraining order department where Commissioner Cohen sits. It used to be the UD courtroom on the 7th floor. It's a pretty big courtroom, and I was in there, and that was actually pretty cool because there was a big screen on the wall, and there was a cam, and you could see a lot of things on that screen. Anything else on that? Because Randy Medina is asking a good question in the chat.
Yeah, so I see a new question came in. Someone stated no flash drives. Why is this a bad idea? So I had mentioned that, and it's because the court is not allowed to stick any flash drives into their computers. No external hardware is allowed to be attached to a computer. That's like the easiest way to transfer a virus. So it's the one thing that's completely off limits. So don't do that because the judge won't do it.
I would love to hear. I would love to hear from people who have actually done this, because as we've been preparing this, and I don't know, Ron, you mentioned you had a couple of hearings, but were those hearings evidentiary hearings where you questioned witnesses and introduced exhibits? Right. There are, I'm not sure how many people we have here. We have 84 participants. Have any of you guys done an evidentiary hearing remotely on video, or have you been in an evidentiary hearing when you were yourself in court, but the other side was on video? Because if the answer is no, I think that also tells us something about, you know, what people in the county are actually doing. We have a pretty good representative sample here.
And go ahead and unmute yourself if you're one of those people that can contribute.
I'm just scrolling through the pictures, trying to see if anyone has their hands raised.
And while we're looking, Randy had a follow-up question. He was planning to upload exhibits into Dropbox and share the link with the court, opposing counsel and parties. Is that a good idea? So I think that would probably depend on your judicial officer. I would say as a general matter, probably not. But you know, some may be more techie and willing to do that. So you know, I think that you shouldn't rely on that. That's why the suggestion of a tablet may be more useful. But certainly you can reach out to the JA and the judicial officer and see whether they'd be fine with it. And sending that to the other side and to the parties certainly would satisfy that need. Another question came in: how can you present a recording by a client that previously was presented on their own, phone, computer, brought to court?
You take that one, Ron, because you're honestly the most technologically savvy one here.
Is this an audio recording? Karen B, if you're out there, unmute yourself and clarify. What kind of recording are we talking about? Hi, Karen.
Hi, Karen.
I'm thinking of a video recording that somebody brought, for example, to get an initial temporary restraining order. And traditionally, they bring a laptop with their flash drive.
Right. So if it's a video and you want to appear remotely, the two options that I think right now I heard that are the best is sending a device that has a video preloaded, or if you're on LACourtConnect like we were, you could try showing the screen on the actual camera, because sharing a screen like we were doing with exhibits wasn't coming across very well. And just a note, in the video playback that we were doing today of our mock trial, I think everyone was probably seeing it choppy. It's not actually that choppy in real life. So it's not quite that bad. It's not amazing, but it's not that bad.
Choice.
What's that?
What do you think is the optimal choice, or should you probably coordinate with the judicial officer?
Well, for the TRO, it's probably even more tricky because of, you know, depending on whether you're in a home court or if you're going through the ROC, you have to deal with those logistics. But certainly, if you can get a hold of a clerk or if you know where you're going, a judicial officer or even the judge, to find out what they could do, that would be the best.
That would be the best shot first.
Yeah,
Okay.
and you know, there's also messengers that can take stuff to court. So if you don't want to appear in person, you can send someone on your behalf to, you know, drop off a player or something with video if that's, you know, feasible.
Okay, thank
A
you.
really good question in the chat on credibility. And Ron, can everyone see the chat, or can just
I think everyone should be able to if they click on it.
Yeah, the question is essentially, did we talk about, while taping this, did we talk about credibility determinations with a party appearing remotely, or is it easier to make a credibility determination in court, even with wearing a mask. I don't think we asked Judge Amarian that question. I would love to hear, from my co-panelists about this. We did a similar presentation to this one a few months ago for the AML, and in that presentation we devoted some time talking about the issues such as how do you make sure that the person is in the room by themselves, how do you make sure that they're not looking at their cell phone and they're not texting with someone who's feeding them the answers, whether it doesn't have to be the lawyer who's in court on the record, right? It could be the lawyer's associate, it could be, so how do you control, not so much for whether the person is lying per se, but just being coached during the hearing.
Yeah, it's tricky. I would say, if you've got video, at least you can actually see someone's face. I know. Again, it was choppy for everyone to see that, but it is doable through video. If they're in, I think Chelsea, you were pointing out, if you're in person, is that what you were saying?
Yeah, so I've heard from some judicial officers that it's interesting being on video this way because they sort of have a front-facing view of the witness rather than sort of the side view they have if the witness is on the witness stand next to them. And I feel like at least the couple of people that I've spoken with have said that that's been sort of helpful to them. They feel like they have a better assessment, seeing the witness full on and kind of seeing what's happening there. But I do agree that it's a little problematic of not being able to assess, especially with all of us looking straight forward at our laptops. If someone's looking at something, notes or exhibits or things like that on their screen as they're testifying, and you can't necessarily tell if that's happening unless, I guess you're paying particular close attention to their eyeballs moving back and forth or something that would scream, I'm reading from a screen. But yeah, that's probably a difficult issue to kind of manage and deal with. And
the flip side of that is in person now, everyone's wearing masks. Everyone's masked. So even witnesses and attorneys that are in the well, that you can't see their face. So any other questions?
Providing John Laser is asking, is providing an electronic copy of the exhibits to opposing counsel sufficient? Despite what I said earlier, I don't think I'm the greatest expert here on the, on the rules of service. But I would say the answer is well. So first of all, there is a stipulation for everything. I think that these days, we're still operating under the emergency rule 12, and so just my initial thought is, if it's sufficient for me to serve my trial brief, witness list, and exhibit list by email, I don't see why the same wouldn't apply to the exhibits. And most of the time, if I believe it's the kind of opposing counsel that will give me a hard time, I would probably verify that in advance, because I would rather, do the print job and send out a binder than be confronted with some time-wasting objection at trial.
Right. Well, it is 3:00. I want to thank Chelsea and Alex and Jennifer Magnes and Judge Marion for participating in the mock trial.
Thank you, everyone.
All. Have a great rest of your Saturday. It's not as rainy or cold as they said it was going to be.
And thanks to the BHBA and thanks to our sponsors. And thanks for everyone for attending.